Good afternoon and welcome to the Appellate Division, First Department. We have almost 6 hours of argument time that is requested. So I'm going to ask that you ask for only that time that you actually need for your argument, not the time that you want. Understanding that the court is fully familiar with your briefs, the record, and usually more than you wish we were. So, and please know that the clock is for you, not for the court. So if the court has additional questions beyond the light, I let the time roll. That being said, could you please call upstairs and have my staff bringing me my glasses if I'm going to be productive on this sit? Thank you. Okay. People versus Sharf King. Okay, submitted. Prado versus BP Cyrus LLC. Okay. 5 and 1 and 4. D Children is submitted. Sales versus Urban American Management. Okay. Okay. 5 and 1, 5 and 1 and 5. Nochi Blue versus Board of Managers. Submitted. 7 Avenue Assets LLC versus Carrion HPD. Okay. 5 and 2 and 5. People versus Wilson Garcia. Wonderful. Welcome. Okay. 2 minutes? Oh, he's confident. 5 and 1 and 2. Vision Bio Bank Holdings versus Talel. Okay. 5 and 2 and 5. Luke versus Mary Manning Walsh Nursing. Okay. 5 and 2 and 5. People versus Jeffrey McVeigh. Okay. 5 and 2 and 5. Simon versus Lewis is submitted. I will surely mess up this name, so forgive me. Rudziewicz versus 164 West 79th Street Court. And forgive me. Tell me how to say it properly. We say Rudakevich. Okay. All right. 5 and 2, 5 and 2 and 5. Bent versus 99 Jane Street Condo. Okay. 5 and 2 and 5. People versus Ismael Maison. Submitted. People versus People of the State of New York versus GPB Capital Holdings. Okay. Okay. 6 and 1, 3 and 2 and 7. Dunnington, Bartholomew, and Miller versus Simon is submitted. First case on the calendar, Prado versus BP Cyrus LLC. You may proceed.
Thank you, Your Honor. May it please the court, my name is Andrew Bandini Amor Lilingna Party, and I represent third-party defendant co-appellant Eurocraft as opposed to the main appellant BP Cyrus. Eurocraft respectfully requests that this court reverses the motion court's order granting summary judgment on plaintiffs' labor law 241 and 241-6 claims. First, the plaintiff Eurocraft asserts that the plaintiff was not entitled to summary judgment on his 241 claim because the testimony of plaintiff's coworker, Rudy Hernandez, created an issue of fact that should go to the jury. Mr. Hernandez had testified that plaintiff missed a step while descending the subject ladder, causing his fall.
Was there an issue of fact put forth regarding the stability of this ladder? And do we get to the other issues if that has not been met?
Your Honor, although the stability of the ladder is not at issue, because...
No.
Oh, I apologize.
So my question, are you conceding that based on this record, what we have is an unstable ladder? No one contested that, am I correct?
Nobody has contested.
So based on our precedent in this department, under our labor law on 240 sub 1, we don't even get to these other issues once it has been established and you have not controverted that you did not provide a proper safety device.
Your Honor, it is Eurocraft's position that the plaintiff may have been the sole proximate cause of his accident.
Again, even under that analysis, you have to establish that you provided a proper safety device, that the ladder was not defective in any way. And on this record, there is nothing that contests plaintiff's assertions, repeated assertions, that this ladder was wobbly.
Plaintiff did testify that he checked that the ladder was level and sturdy before ascending it.
Did he
So
say it was wobbly?
he said later in his
He
deposition,
said repeatedly it was wobbly. We read the record, okay?
I understand, Your
So how do we get past that you haven't provided a proper equipment under the 240 sub 1 statute? We don't even get to the other issues.
Your Honor, there has been precedent that if the plaintiff misses a rung of the ladder, he could be considered the sole proximate cause.
What if he misses the rung of the ladder because the ladder wobbled and in essence, he missed a step. He missed a rung because he was out of balance all of a sudden.
There is a possibility that that could have occurred, but we believe Eurocraft's position is that that should be submitted to the jury.
So as my colleague has raised, there's no issue of fact, no controversy here that this ladder was wobbly. I mean, it's all over the record. He testified that the ladder, no matter how you placed it, wobbled. And as he used it, the ladder wobbled. And no one, not even your own witness, Hernandez, who submitted an affidavit, disputed that fact, that he was provided with a wobbly ladder.
Your Honor, again, it is Eurocraft's position that the plaintiff would have been the sole proximate cause of his accident, irrespective of if the ladder was wobbly or not.
So, counsel, isn't it true that the plaintiff requested that someone hold or brace the ladder, and that the individual, I think Carlos, indicated that there wasn't enough workers to do that?
That is correct, Your Honor.
Why wouldn't that at least give rise to at least 1% liability? And that would not be sole proximate cause. If a worker is saying, I need someone to brace it because it was unstable, that would mean there's some liability based upon the failure to provide an adequate device.
Your Honor, the plaintiff had testified that he ensured that the ladder was level and sturdy before ascending it.
He also testified that he felt that a scaffold would have been the adequate safety device for this type of work. And he requested that one be provided, and he was told, what we have is these ladders. And by the way, according to him, all the ladders were wobbly.
Your Honor, although the plaintiff did testify in that regard, Eurocraft's position is still that the plaintiff had missed an entire rung of the ladder and therefore was the sole proximate cause of his accident. Thank you, Your
It
Honor.
doesn't matter the condition of the ladder. The ladder could be standing on one leg, and that's it. It doesn't matter. He misses a rung, so it's on him. is your client's position.
Well, Your Honor, the plaintiff did testify that he checked the stability of the ladder before.
And he also testified that all of the ladders were wobbly and that he asked for other equipment which was not available, that he asked for a worker to hold the ladder because it was wobbly and was told, sorry, work it out. Am I right?
You are correct, Your Honor.
Thank you.
Thank you.
You'll have time on rebuttal.
Thank you.
Wait one moment, she arrived late. The court is allowing counsel 3 minutes to argue.
I just want to
Things
thank
happen,
the
I get it.
bench. I'm never late, so I do apologize. Since you have discussed the main issues, I want to bring up a case that was decided after I submitted my opening brief, but was decided on March 27th, and it's in my reply brief. It's the Arias versus Brooks Holdings Corp case. Judge Mendez was on that case. In that case, there was an explosion. It was an electrical explosion, and it didn't contact the plaintiff, but it caused both the ladder and the plaintiff to fall.
Here, the ladder was the problem. There was no external force like an explosion, so I don't see that case as being on point at all. So why don't we get to the issue at hand and address that, because I don't think that case really assists you.
It does actually, Your Honor, because if you look at the first description of the accident by the plaintiff in his first deposition, he initially says that as he's working, the gate that he was cutting, the fence, fell away, hit the ladder, and that was the precipitating cause.
Which means that the ladder was unsecured. And so an object hitting it would cause it to fall over, which in and of itself is a 240 sub 1 violation, counsel. So I don't see how that fact pattern helps you.
Well, the problem with that is that an A-frame ladder has never been determined, other than in this court, as an unsecured item. It stands on four legs.
Actually, our court's decisions have been affirmed by the Court of Appeals repeatedly, counsel. So I take umbrage to your statement.
My statement is that basically OSHA, and there's no other industrial code that has decided, for example, that an A-frame ladder is insufficient.
Perhaps more broadly speaking, it's that the A-frame ladder wasn't an adequate safety device given the particular task at hand, which would necessarily involve falling debris.
Well, so the plaintiff says that what he should have been given is a scaffold, but the issue with the scaffold is that also stands on four legs. So what difference is there? He says
Are you
that actually.
kidding me?
Well, he
You're
says.
going to compare an A-frame ladder to a scaffold?
Well,
Even a baker's scaffold.
it would have been a baker's scaffold because
It's a better
12-foot height.
surface and working environment than a ladder is every day of the week.
But again, he used the scaffold. He used the ladder all
Because
day
he
long.
had no choice.
No. I'm saying he used it without falling. The precipitating event in this case was that the fence hit the ladder. And he says he wasn't actually he later clarified he wasn't actually cutting at the time, that he had stopped, he was waiting there for a few seconds, and then the fence fell and hit the ladder. So under those circumstances, the ladder, although described as old, although he indicates that there were some issues with it, he doesn't say that it was, it's not inadequate when one considers the cause of the accident.
Thank you.
Thank you.
Good afternoon. May it please the court, Vincent Chirico for the plaintiff respondent. Our position is that the lower court correctly recognized that an inadequate ladder remains inadequate regardless of whether the worker fell because it shook, because it shifted, because it slipped, or because it caused them to miss a step. And to that, I cite to this court's case in Brito from earlier this year, which has the same exact facts. Defendants argued the plaintiff missed a step rather than fell because the ladder wobbled, and this court held that the claim rested only on an uncertified medical records, which defendants rest on here, and the fact that the ladder remained upright, as in the Pilapanta case, doesn't matter, okay? So If the ladder's instability caused plaintiff to lose his footing, it's a 240 violation. If the ladder slipped and fell, or tipped and fell, it's a violation. If the ladder moved when it was struck because it was inadequately secured, it's a violation. Here, as the court noted, plaintiff testified that, yes, he checked the locks to make sure they were in place. When he checked the locks, the ladder was still unstable. He said the workers needed a scaffold or a rope to tie the ladder down. He asked Carlos, his foreman, for someone to hold the ladder or to brace the bottom of the ladder, but Carlos said everyone had to work on a fence, so there was nobody else, no other way to hold the ladder or secure the ladder. I agree with the court that certainly a scaffold would have been
This
better.
work, if I'm correct, this is after a construction job has been completed, they're just tearing down the fence.
Tearing down the fence.
Right, so it's not like in some cases where there's urgent work that needs to be done quickly, that people are a little looser in their safety concerns. Here, there was no rush.
That's right, Your Honor.
There was no reason to put workers at risk.
That's right, Your Honor. It was the end of the construction project. To the extent that the court wishes to address the 241 sub 6, our position is that we're entitled to summary judgment there as well, pursuant to a per se violation of Industrial Code Section 23-1.1b sub 4 that requires that all ladder footings shall be firm, slippery surfaces and insecure objects shall not be used as ladder footings. Again, here plaintiff checked the stability of the ladder. It was wobbly, it was defective per se, and because of that, we believe we're entitled to summary judgment on 241 sub 6 as well. There's no other questions?
Thank you.
Thank you.
Counsel, you have a minute.
Your Honors, very quickly, Brito is distinguishable because we do not rest on uncertified medical records in whole. We rest mostly on an affidavit from an eyewitness stating that the plaintiff missed a rung of the ladder.
Thank you.
Thank you.
All right. Next case, Sales versus Urban American Management. Okay, one sits on that side, one sits on this side, that's all. Let us know who you're representing.
May it please the court, Nicholas Bruno from Horn Appellate Group, representing the appellant owners.
Okay,
The motion court erred in denying
bring that mic up closer to you. Okay.
The motion court erred in denying the owner's motion for summary judgment on the issue of contractual indemnification by Schindler, and for awarding the plaintiff's summary judgment motion despite his failure to establish causation. Concerning the former, the plain terms of the indemnification agreement do not require a finding of the owner's negligence. They only require that personal injuries arose out of or in connection to Schindler's performance of the comprehensive service agreement, which the record plainly establishes. For example, there's ample evidence establishing that it was Schindler's negligent maintenance that caused the accident, specifically identified, for example, in the breach letters, which were sent from the owners.
How about their communications to your people that these elevators that are original to the construction from 1975 are antiquated, need modernizing, or full-out replacement? So you don't get to walk away from your share in this by ignoring the professional advice of the elevator company that you hired to maintain the elevators. You don't get to say, maintain it, do everything, we're shifting all the duty to you, but we get to ignore you when you say, this needs to be completely replaced, this is antiquated, it's a problem. And the records here show that repeatedly.
Respectfully, Your Honor, we disagree. We do not dispute that Schindler recommended the modernization process, but we dispute that there's any evidence of a causal connection between the accident and the
Well, the very
obsolete
things that were
components.
being complained about and reported in the notes about what was happening with this elevator is exactly what happened. And unfortunately for you, it happened to be a buildings department inspector who gets hurt in that elevator, right? So
Respectfully, I will refer to the court
you
to
can drop the respectfully, we know what that means.
refer to the court to pages 6 and 7 of my reply brief, which discusses why the two Swift Futura components, which were the obsolete components identified in the upgrade request orders in which the motion court relied, could not have caused the accident.
Are these related to floor leveling or to jumping or stopping suddenly?
So the selector, which is one of the Swift Futura components, is related to leveling and selecting which floor the elevator appears on. But Schindler's own witness, Mr. Walters, on pages 602 and 603 of the record, said under no circumstances could the selector have caused the elevator to drop multiple
Is this the
floors.
same witness who said never in his 30 years in the business has he seen a worse elevator? A worse elevator kept by any building that he has serviced in all of New York? That witness?
And that goes to
I didn't hear a yes or a no.
yes, Your Honor.
It was that witness, right? So the fact that he says that when you juxtapose it against what I just said, and I know I may have been a little bit, right? But I think I got the gist of what he said, right?
Yes, but that does go to the maintenance and the
It
long
doesn't?
years of breach.
It doesn't?
No, does, which is why we're arguing that Schindler should indemnify us because the.
Yeah, but, excuse me.
Go
but
ahead, please.
I understand your position, but would you say on this record that there's the possibility that a jury could find you 1% based on the exception, the contractual exception of obsolescence? I mean, you raise it in your reply brief, but still, there's still that possibility of 1%. And if there's 1%, minimally, it can't be outright contractual indemnification, it's possibly conditional. Would you agree?
I do not agree, Your Honor. There is no evidence outside of the suggestion to upgrade, the upgrade orders. There is no causal evidence establishing that the accident occurred because of the obsolete components. There's no
But
evidence in the
these are
record.
the components actually that would cause the elevator to malfunction the way it did, according to what you're saying.
There is no evidence of that. There's no testimony suggesting
And
that.
that's what a jury will let us know. Thank you.
Good afternoon, Your Honors. Patrick Engel, Keller O'Reilly and Watson for Defendant Schindler Elevator Corporation.
Counsel, would you agree that contractually, the language which says that while it allows a damages exception and obsolescence is not being covered under your maintenance contract, that the following clause, it being understood that under no circumstances will any elevator be left in an unsafe condition, that somehow keeps you in the loop to the very end?
Your Honor, just understand why Schindler's here today. All we are saying, there are questions of fact that preclude the granting of summary judgment to the plaintiff with regard to the happening of
I'd
this
like
accident.
you to answer my colleague's
Also,
question.
the bottom line on it, Your Honor, that contract said, we are not responsible for obsolescence. We can tell the owner about obsolescence. We can tell the owner what has to be done with regard to
You are
obsolescence.
permitted under that contract to allow an elevator that is unsafe to remain online and not taken out of service in light of that contract?
The contract specifically says, now we're talking about what's the obligations of the very parties. Obviously, in premises liability law, the owner is responsible for the maintenance and care of an entire building, including the escalators.
Right,
and
and
elevators.
the contract that they entered with your client transferred the duty of maintenance of that elevator to Schindler. So my question to you is, I understand your argument about the obsolescence, right, of the elevator and whether that thus means that the owner is also potentially liable. I understand that argument. But to argue that that Schindler, not you personally, that Schindler gets out because of it, that's not your argument today, is it?
Your Honor, again, I repeat, I am saying that we have a contract with the owner. The contract says we're responsible for maintenance. Our contract with regard to obsolescence says we're supposed to tell the owner about obsolescence. We told the owner about obsolescence, and it's more than just the controls, by the way. If you look at the communications, it's numerous issues. Like the court has pointed out, it's a 1975 elevator.
Right, but the emails didn't say there is absolutely no way of getting these parts, we're trying. Isn't that what you said? So
Actually,
again, my question, and you still haven't answered it, by the way. My question is your argument that that Schindler should be out based on this issue of obsolescence?
my argument is that the obligation taken on by Schindler wasn't with regard to obsolescence. Schindler can shut down an elevator temporarily when they get a maintenance call from an owner if they're not present when when the issue comes up. And in this instance, that's exactly what happened.
So let me ask you a question. Let me ask. I need to understand, right? So are you saying that if Schindler, expert elevator repair people, go to this building and determine this elevator should never have the power put on it again because it is that dangerous, you're telling me that you can't communicate that to the building owner and say, I absolve myself of any liability. That elevator needs to be taken out. It doesn't work. We cannot fix it. You can't do that?
Your Honor, that's exactly what the correspondence.
That is not what the correspondence. That is not what the correspondence said. Now I'm a turn what the others said do to me all the time. With all
in
due
New York,
respect,
Your Honor.
That's not what the email says.
The contract between the two parties said specifically accepted obsolescence. As a matter of fact, Your Honor, if you look at the subsequent company that came in, Centennial, they not only did they say you have to address all these issues, and they're not taking on the responsibility for obsolescence. The owner of the building was responsible for obsolescence. The obligation of Schindler in this instance was to do exactly what it did. When they got the calls, they would shut down an elevator, and they would tell the owner what happened. The owner was told numerous times that there's an issue with regard to obsolescence. In New York, in a contract, although you can be liable to a plaintiff or another party with regard to the duties you take on, you cannot be held liable by contract for something that you did not accept by contract. In this case, it's obsolescence. That's the entire point. Our contractual obligation is to continue to tell the owner that he had a problem with obsolescence. The record reflects that. The owner was objecting to the cost. The owner, in the guise of saying it's a negligent or it's a maintenance issue, actually had an obsolescence issue. Like you said initially, Your Honor, 1975. This is a 1975 elevator. Schindler is doing what it can, and it does what it can, and it tells the owner that you have an obsolescence issue. And each time it tries to address the obsolescence issue, it tells the owner that, by the way, not only do you have an obsolescence issue, there's even parts you can no longer get, and you can no longer get at all. And the owner turned around and said, well, that's a maintenance issue. That's not a maintenance issue, Your Honor. It's clear that it's an obsolescence issue. And we did not accept the duty with regard to obsolescence.
Thank you.
To the plaintiff, I should say. Thank you, Your Honor.
You may proceed. Good
Good afternoon, Your Honors. Jillian Rosen for the plaintiff respondent. I think obsolescence is a red herring, and here's why. So we know that there were 17 complaints about this elevator car, but focusing on the 4 that deals with jumping and bumping and whatever other adjective you want to use that shows it's in disrepair, the one that's really important is May 7th, and here's why. So May 7th, Schindler gets called by the building, jumping, bumping, and they come, and Schindler's own witnesses testify that there is no evidence that this elevator was fixed. Until when? The 14th, which is 3 days after the plaintiff gets injured. So forget obsolescence for a minute. They have a comprehensive maintenance contract. They are to maintain, it's just,
I mean, from your perspective, I understand why that issue is not important, but as between them, it is very important. So forget that issue, this court ain't doing that. It absolutely has everything to do as between them.
sure.
So I understand how,
Okay.
from the plaintiff's
Okay.
perspective, you guys work that out, I get that.
Sure, I just wanted to just address
Okay.
the obsolescence. I know that that is even not, that's not even what they're
You're
saying.
saying it's a red herring, it's not a red
Well,
herring.
no,
As between them,
Yes.
it is a live issue.
No, I understand that. I'm just talking about with regard to what happened on May 7th, that was a maintenance issue that they didn't come and repair and fix, and they didn't take it out of service. That's what I mean by a red herring.
Fair enough. Why don't you, your friends are constantly arguing that you should not be awarded summary judgment because the damages or the hospital, the medical records don't support the dropping or the jumping or whatever adjective
Right.
causes his injuries. But really, it's really damages. It has nothing to do with liability.
Correct, to the extent of the nature and there's nothing stopping the defendants at a damages and apportionment of fault trial for putting on a defense and saying this wasn't, that the extent of the injury wasn't as severe as the plaintiff is saying, or it wasn't caused by that. But I'd like to point out that let's take the reply aside for a second. In plaintiff's main motion, the bill of particulars was submitted, which actually states that these injuries were proximately caused by the elevator incident, and attaches operative reports. The operative reports don't necessarily per se talk about proximate cause. However, one of them actually on 1391 of the record talks about a cervical disc injury after a traumatic injury. So there is some allusion to trauma with regard to what was submitted in the main motion. Now, with respect to the reply, that was permissible and within the judge's discretion to allow that. It's not new evidence. What it was in response to the defendant's specific allegation that what the plaintiff put in with regard to damages wasn't enough. So what the plaintiff did was then put in the treating doctor's reports that talk about proximate cause to the elevator accident and that he's permanently disabled. In addition,
But the movement for summary judgment can't rely on reply to correct defects or omissions in the underlying prima facie showing. So I guess the million-dollar question is, was your underlying presentation sufficient to discharge a prima facie burden?
I believe in addition to what we submitted, the plaintiff did testify at 177 of the record that he immediately felt pain when the elevator dropped. He grabbed the bar to prevent himself from falling. And again, the defendants say, well, your feet didn't leave the ground. You didn't get thrashed around the elevator. We all know that you can get injured by preventing yourself from falling. So he grabbed the bar, tried to prevent himself from falling. He testified that immediately he felt back pain. He walked down the stairs, told the building manager something happened. Then his own supervisor takes him to the hospital, to the ER, where he complained of neck pain, back pain, shoulder pain. He was out of work for 3 months. Eventually, he couldn't work at all. So our position is that in conjunction with his deposition testimony and the bill of particulars that attaches the operative report, what we did on reply wasn't really correcting a defect. It was, I don't know if the word is embellishing, but certainly it wasn't like we didn't.
Elaborating?
Possibly, but it wasn't something new, is what I'm trying to say. It's not like the plaintiff didn't testify that he was injured, where he felt the pain, that he felt it immediately. It's not that the plaintiff in the bill of particulars didn't say this is what was caused by listed the injuries and attached operative reports where it says traumatic injury. So for all those reasons, I don't think that the reply was really was correcting a defect. I think what plaintiff had enough on their motion establishes that he was injured. And to the other point is that could be taken up at a damages trial and an apportionment, at which point, by the way, the indemnification will come into play. It's premature at this point without an apportionment of fault. And obviously the elevator company, the building owner can't be indemnified for his own negligence. Any other questions?
Thank you.
I will rest my brief. Thank you.
All right. You have 1 minute.
So counsel, I had a question. Assuming arguendo that the owner is at least 1% liable, would there be contractual indemnification or contingent indemnification, or would it be a tribal issue of fact?
We believe that the case law supports, at the very least, conditional indemnification.
But I thought the case law says you have to show that you're free from negligence, and we don't permit, as a public policy, to permit tortfeasors to obviate their own negligence.
A couple of points on that. I'd like to direct the court to both Ezard and Kamaj, where the court granted conditional indemnification based on similar language, without a specific finding as to negligence for the owner.
In those cases, was at least the owner 1% liable? Assuming, I'm not saying that's the case here.
There was no, in those decisions, they hadn't reached a specific finding.
So
as
is
to-
it premature, as your friend just mentioned?
Not necessarily for conditional indemnification, no.
Thank you.
Thank you.
Couple of points, Your Honor. First of all, the first thing with regard to any motion for summary judgment made by any party is that they may make a prima facie showing to entitlement to summary judgment. The judge, in this case, put out the basis for a motion for summary judgment on negligence, duty, breach, cause, and harm. Okay, so what happened is the judge, in her opinion, said that said the plaintiff made a prima facie showing, and then the judge didn't cite to the bill of particulars, didn't cite to expert testimony, didn't cite to anything other than what the plaintiff submitted in the reply affirmation. And what is really particular, the judge also said that defendants did not make a showing showing with regard to causation. The defendants were never given a chance to make a showing with regard to causation because it was done on a reply, and the defendants were not given an opportunity to submit anything with regard to causation. So missing was duty, breach, cause, and harm. Quickly, with regard...
You are out of time, my friend. We have your briefs and the record. Thank you so much. No, they are submitted. 7th Avenue Assets, LLC versus Carry On. You may proceed.
Good afternoon, Simon Rothkrug for the appellant. May it please the court. This is an Article 78 proceeding. Normally, I have a very high bar to leap over with the arbitrary and capricious.
Still do.
But not in this case, Your Honor.
Article 78 bar is an Article 78 bar, and you
Well,
have it, my friend. So let's see how you do.
That bar gets significantly lowered when you have a clear question of statutory language with plain English words, and it gets even lower when you have a clear legislative history here and what the legislative intent was. So first, the legislative intent. We know that this statute was amended to broaden the scope of buildings that could qualify for the tax abatement. Actually, the language was to encourage creative redevelopment to a broader range of buildings. This is such a building. And then the legislature used language of horizontal floor area.
Well, you rest on the fact that there was the absence of flooring because of the fire, and you're taking it that way, but it's clearly there's a percentage component here that they want to see an increase both horizontally and height-wise, and that didn't occur here. So because it was fire damage and there was the absence of a real floor, you're saying you're entitled to the abatement.
I disagree 100%. Your
Well, I
Honor.
know you do.
And you said height-wise,
But
Your Honor.
counsel,
You
I
said
have a more,
height-wise. That is
more
nowhere
fundamental,
in the statute.
excuse me, I have a more fundamental question, because this case mystifies me. And I know it wasn't brief. The building was substantially rehabilitated in at least 2013. That means it was the equivalent of a gut demolition. You took 16 substandard B SRO units that were burned out, and you created 18 Class A residential apartments, which means quantitatively and quantitatively, you increased the housing stock. Under the rent stabilization provisions in this city, this building was deregulated by operation of law. So you wait 11 years from 2013 to 2024 for HPD or DOB to issue you a tax exemption under 421A to now subject the tenant in the building to rent stabilization for the life of this tax abatement. I don't understand this. Why didn't you go into court in 2013 and get a declaration that this building was deregulated? You would have made your money back tenfold.
This application has been pending at HPD forever. It took them
Not for 10 years.
Not for
Counsel,
10
come
years.
The application was filed, but we're getting away from this.
No, we're not.
no, we're
because
not.
Building.
We're not, because you're seeking 11 years to get a tax abatement when you did the work to be deregulated. You should have gone to DHCR or to the court and got a declaration that this building was deregulated. You would have had free market rents. Are the tenants here subject to rent stabilization?
When you obtain a tax abatement, the answer is yes.
Now,
When you obtain a
but
tax
that means
abatement,
they've been
they are subject-
deregulated this whole time, right?
Pardon me?
That means the owner of the building has been getting market rents.
No, we have not been getting market rents. These are, and if you look at the application, the 421 application is in the record. It shows the rents, the permitted rents, and we've been living by those permitted rents. This is a rent-stabilized building. We've been operating this building as if it was going to obtain the tax abatement. We couldn't have it both ways. Your Honor is implying that we could have it both ways, and we
No,
can't.
I didn't say you could have it both ways. I'm saying that someone was misguiding your client 11 years ago. And it makes no sense.
It makes no sense that it takes 7, 8 years for HPD to make a determination on this issue.
But getting back to the issue at hand, you do not dispute that the footprint didn't change in this building.
That is correct. It's a mathematical formula, and it does not require an increase in height. It requires floor. And this is not a building that my client acquired. Then there was the fire. My client, during the fire, demolishes it. Your Honor used the word demolish. My client didn't do any of that work. That would be a different story. My client acquired a building that had already been fire damaged, that already had no floors whatsoever. Might be different if my client suffered the fire and during
I don't
repair
think
work demolished the floor.
I don't think it's relevant who owned the building or when the fire occurred. The bottom line is a vacant, empty building was rehabilitated. And you put in brand new units, all good. And the question becomes are you entitled to 421A based on the square footage?
Based on the creation of horizontal floor area where none existed.
And does that phrase have a clear and unambiguous meaning?
I think it does, and I think it's plain English, doesn't require an agency to give expert opinions on it. The legislature, again, and the intent of the legislature is critical. We want to broaden the scope. We want to encourage this kind of development. This is a beautiful building with 20-foot high ceilings. If I wanted to cut this in half with floor area and create 2 floors of 10-foot ceilings, I don't increase the height of the building. I don't increase the walls. I've created floor area within my 4 walls, and that's exactly what the law was intended to allow. That's the creative use and the creative redevelopment to create affordable housing in the city of New York. That's why it was passed.
You'll have time on rebuttal.
Good afternoon, Rebecca Viscatas for the respondents. HPD rationally determined that petitioner's interior reconstruction of its building did was not eligible for tax benefits under the 421A program for new multiple dwellings. Under principles of both agency deference and the strict construction of tax exemptions, petitioner had to show that the text of 421A1C clearly and unambiguously applied to its project. Petitioner cannot meet this high bar. I agree with you that the long process from when they originally applied to when they finalized their application, I think it was, I want to say about 10 years until they submitted an updated affidavit arguing that the building had no pre-existing floor area.
So wait,
there
you
was
just said something interesting. You said they started an application process, but did not complete that till when?
Until 2021, I believe.
So if we're at 2026, at most, it would be 5 years, and I imagine that the appeal process took some time.
Yes, I mean, this does seem to have been a very long process, but, and it's not all laid out in the record, but my understanding is that there was a lot of back and forth over the intervening years of HPD asking them for more information to support their application and giving them opportunity to establish their eligibility, and ultimately they still couldn't move the bar.
I've asked this question of other litigants in the past because it seems to me that we want to encourage exactly what this building owner did, right? I mean, they took a building that would have otherwise probably ended up condemned, and they fixed it, and now there are 18 people, families that have a proper place to live. So why does it matter in terms of the length of time to complete the application, the timing of it, what precipitated it, which I know was part of the discussion in the briefs? Why does it matter? And in light of the fact that they went from single room occupancy, rate B, as my colleague pointed out, to 18 rate A apartments, which this city sorely needs, why does this not qualify?
I absolutely agree that that the city needs housing like this, and that's why there is an additional program that this building very well might have qualified for.
You're talking about J51?
Yes, for rehabilitating buildings that are not inhabitable or not inhabitable to the fullest extent. And that program, petitioner entirely ignores and frames this as if it was 421A or nothing.
Well, with respect to 421A, does the phrase floor area, as it's defined in 421-A1C, somewhere in that
Yes.
neighborhood, does that have a plain and unambiguous meaning?
So I think the question is whether the provision clearly and unambiguously encompasses petitioner's project. Petitioner wants to focus on the meaning of floor area, but they use the phrase pre-existing floor area throughout their briefing. Pre-existing floor area does not appear in the statute.
Well, I think if I remember from your friend's brief correctly, one of the points they make is the word floor would be rendered meaningless or superfluous if we didn't use his the definition he's operating with.
That's incorrect, Your Honor. And the reason why is because 421A1C makes clear that new multiple dwelling includes new residential construction and the concurrent conversion, alteration, or improvement of a pre-existing building or structure if no more than 40% of the floor area of the finished project consists of the pre-existing building or structure that was converted, altered, or improved.
So
Petitioner
how
is
do you
reading.
address the word horizontal areas of the floors? So I understand if you do the space encompassing the pre-existing walls, but how do you address horizontal? They didn't just say floor area, which is a normal term of art. They talked about a horizontal floor.
Right. The answer is that they're talking about the horizontal floor area of the completed structure and whether that is within the pre-existing building or in addition to it. And they did this, they did not say that no more than 49% was pre-existing or no more than 49% existed in the previous structure. They said no more than 49% consists of the pre-existing building or structure. That's talking about the exterior shell. As much as petitioner tries to argue that the legislature should have used those words, that is what they're getting at. And that's especially
So
clear.
your HPD's reading is that for them to have qualified, they would have had to build up
Or out.
build out
Exactly.
in order to go at least 50% beyond what was already in that building.
That's exactly right. And there could have been other nuanced things if they had built up or out, but also somehow decreased the number of floors overall or something. But the idea is that there were legislative reasons that are clear when you look at the legislative history of this law and the concurrent amendment of the J51 law that were showing that this was designed to target conversions and alterations that also included a component of adding up or out. The J51 program was to cover buildings that existed within the existing footprint.
Got it. Thank you.
Thank you.
Counsel, you have time on rebuttal, and we cut you off so much, I'm gonna give you an extra minute.
Well, I appreciate it, thank you. I think the record does show that the applicant, my client, diligently pursued this application. Record, page 190, shows a checklist. A checklist is like a objection letter from HPD in 2012. Record 201 is a checklist in 2013. In other words, my client responded to the 2012 checklist. They got another checklist in 2013. There's another checklist in 2014. It appears at record page 206. There's another checklist in 2015. That appears at record page 215.
Counsel, did they ever communicate to you that maybe you should apply for the J51 instead?
No, I don't think that's their job, and I don't think that's what the law requires. The law, they're two separate.
When have you ever considered that?
I don't think it's relevant. It's too late now, let's put it that way. This was filed in 2012 as a 421A application under the law, which they felt, the owner felt they fully qualified for.
But you shouldn't really ignore that possibility. Again, I'm not trying to be pro you or pro them, but the reality is you took substandard housing, a vacant building, and you created 18 Class A apartments. You made a wonderful building here. And based on the actual legal criteria and the well-settled precedent before 2019, when the HSTPA was enacted, your building could be free from any kind of rent regulation.
Historically, 421A was only for new construction. They amended the law to allow alterations, and they did not use any kind of volumetric formula. The legislature did not choose a building envelope formula. They chose horizontal, they chose the definite floor area and horizontal floors.
So what does this mean when the legislative history says projects involve the rehabilitation of an existing multiple dwelling and/or conversion of non-residential space into residential space as long as at least 51% of the development is new space? How do you interpret that?
Reading it as a whole, the 51% test speaks to creation of floor area. If we accept that there was no floor area, to me, either we accept there was no floor area in this building, there was no, and they used the word horizontal, not even just floor area. Horizontal is a key word. So you can't get around that. And if we accept the fact that there were no floors in this building, and we have pictures, you can look from the roof all the way down to the basement, and the Department of Buildings issued a violation clearly stating there are no floors, no horizontal floors in this building. We complied, you have an applicant who complied with the law. They didn't go to J51, that's fine. They did 421A because the 421A spoke exactly to this situation. They created new housing, they're entitled to the tax abatement. The record does show that they vigorously pursued this application nonstop, and it was HPD's delays in trying to deny this application every which way, which gets us to this point 10, 15 years later. Not my client's fault.
Thank you.
Thank you.
People versus Wilson Garcia. You may proceed.
Good afternoon, Your Honors. Erpi Lavora, Legal Aid Society for Mr. Wilson Garcia. Recently misdiagnosed and improperly medicated, Mr. Garcia was hallucinating when he perceived a stranger as a threat and pushed them onto subway tracks. Horrified by his actions and recognizing the role his mental illnesses played in them, Mr. Garcia has since demonstrated an unparalleled commitment to treatment with the appropriate medication. His 9-year prison sentence is excessive and should be reduced in the interest of justice so he can begin re-entry with support from docs and his family.
You know, I find it interesting that you rest on the fact that, thank God, the victim was not either severely injured or killed. Is that a valid factor here?
All of the factors that, all of the facts of the case are relevant in the determination of whether this sentence was unduly harsh or excessive. And including in that, among those things, is the nature of the injury, and of course the event itself, the offense itself, as well as Mr. Garcia's condition at the time of the offense. He was experiencing an acute psychotic episode, was hallucinating at the time of the offense.
Was this somehow also caused by his ingestion of some type of controlled substance?
Yes. Mr. Garcia at that time, because he was misdiagnosed, was improperly treated. His medication didn't work for him, and it's widely recognized that—
He's self-medicated?
Yes, he was self-medicating at the time, and the CHS clinicians—
With what was he self-medicating with?
I believe at that time he had ingested cocaine and K2 drugs that he—
So even if he didn't have a mental illness, those type of things will make you hallucinate and see things and hear things on their own.
Yes, that absolutely might be the case, but the CHS clinicians also noted that they believe that it was the self-medication together with the mental illness that it essentially exacerbated the mental illness. And
How much time was he facing? Had he gone to trial?
I believe he was facing 25 at the top charge, and then he pled to attempted assault 1, where the maximum would have been 15 years.
And it was the court that actually offered this defendant 9 years after having reviewed their pre-pleading memorandum that was submitted by the defense, correct?
I believe it was a prosecution plea that was offered for 9 years, but the court did accept the plea for 9 years with
So
5 years.
that is quite a reduction from the 25 he faced.
The 15 years is the relevant
No,
maximum.
25 is the relevant because that's what he faced if he had gone to trial.
Yes.
15 was the maximum on the plea he took.
Yes.
That is not what he was facing. He was facing 25, so 9 out of 25 was a pretty good deal.
Yes.
In light of the fact that your client, and perhaps because of his state, was arrested at the scene with dozens of witnesses who were present on the subway platform and who, thank God, were present to save the life of this victim, right? Because there was a train oncoming.
Yes. The 9-year sentence is still an almost decade-long sentence, almost 3.5 times the minimum for the crime of conviction here. And
So what are you suggesting that if we were to accept your argument and reduce, what would you suggest we reduce to?
Mr. Garcia would request the reduction to 5 years prison time, acknowledging that after he is released from prison, he will continue to be under post-release supervision for 5 years after the fact, and will continue to have that support and supervision ongoing from docs, and continue to also have support from his family at that time, and also noting that the support from both of these entities, both docs and his family, will help him continue to stay on his treatment plan that is working for him now. He's taking medication that has put his symptoms into remission. He has a much clearer understanding of exactly—
But that has happened to him in the past. He's been hospitalized. He's been basically achieves his best baseline, gets released, and then he goes back to using drugs and decompensating all over again?
If I may. Yes, he has been in and out of hospitals, but as I mentioned, he was misdiagnosed and was not on treatment or not taking medication that worked for him, and so that kind of continued to lead to the cycle. And also wanting to flag that the time period during which this was happening was 2020 to 2022, when the whole world was experiencing COVID. His life was incredibly unstable. He did not have consistent housing, and of course didn't have continued access to support and medication.
We'll have time on rebuttal.
Thank you.
Proceed.
Thank you, Your Honor. Good afternoon. May it please the court, Assistant District Attorney Max Bernstein for the people. This was an incredibly serious crime to which defendant understandably pled guilty and for which he received a considerable benefit. Not only a far more lenient sentence than he would have received had he gone to trial and been convicted, as he almost certainly would have done, but also he had the dismissal of a separate case for forcible touching as part of this plea agreement that was covered here. This was an exceptionally good deal for defendant. It's understandable that he pled.
Was that separate case a felony or a misdemeanor?
It was a misdemeanor, Your Honor, but I think it's fair to say a fairly serious misdemeanor. And I think in any case, again, even if this case were alone on its own terms, even without that additional charge, the deal was, I think, more than fair under the circumstances. And had defendant gone to trial, he would have faced almost certainly a vastly more serious sentence. And he didn't, for reasons that I think the Judge Manzanet Daniels covered quite well, that the facts of the evidence against him was immensely strong. There were dozens of witnesses. So, again, if Your Honors have no further questions, I'll rest on my brief.
Thank you.
Thank you.
I didn't see on this record, counsel, that your client fully appreciated what he did and showed real remorse for the victim. I know he focused on himself. It was my drugs, it was my mental health. But in terms of real remorse, at the plea, he had to be coaxed by the court to actually acknowledge what he did. And even at sentencing, he never apologized to the victim. I mean, that's why I said in your brief, you make a big deal about saying that the victim wasn't seriously injured or killed, thank God. But this was really serious, and he still hasn't acknowledged what he did. And I didn't hear that in your argument.
I think we all, including Mr. Garcia, are incredibly fortunate and grateful that the complainant was not injured more seriously than he was. As I mentioned, Mr. Garcia was horrified by his own actions. He was in a psychotic episode and then realized that he had harmed somebody and it caused them really serious harm. And he does acknowledge that to the court, and also the forensic psychiatrist notes that he demonstrates that there was the common theme of her interviews with him was his overwhelming remorse for the actions that he committed. And I think the most important, or one of the most important things here, is that since the offense, since being incarcerated and being properly diagnosed and properly treated, Mr. Garcia has a very unique and substantial insight into his own conditions at this time, and that has helped him with this incredible commitment and the unparalleled commitment that the forensic psychiatrist notes to his treatment and to being a positive contributing member of society.
I want to, on behalf of this court, thank you, Ms. Vora, for an excellent job.
Thank you.
You did a great job too, but she's fresh out of the gate, so we've got to give her props. You did a great job. This was a tough case to argue, and you did beautifully.
Thank you so much, Your
Thank you
Honors.
so much.
Have a great day.
You too. Vision Biobank Holdings versus Talel.
May it please the court, and good afternoon. My name is Michael Scotto, and I represent David Lesson, who was an officer and director of Vision Biobank for approximately 4.5 months from its inception in December of 2019 until he resigned in May of 2020. The motion before the court, or the appeal before the court, the complaint does not state a cause of action as to any of the three causes of action, and it's not because they're not properly pled. The respondent's brief talks about, well, potentially amendments, other things. They talked about things that were not in the record, but even if all those things were in the record, it comes down to this basic fact. Vision Biobank could not have been defrauded by its own private placement memo or to sales discs that were sent to investors. They don't suffer any harm. They can never allege that they did. So that's as a threshold
Well,
district.
that's based on your argument that the statements in the PPM are forward-looking.
Well,
So if I disagree with that, and I do, then where are we?
well, Judge, I think it still falls on Vision actually raise money through the PPM. This is not an action on behalf of the investors of
Look,
Vision.
if investing in a company and having a PPM that says X, Y, and Z are part of our corporate governance, we have PricewaterhouseCoopers as our auditor. That establishes confidence in the investor.
And
Confidence that they rely on when putting their money down. So I don't understand your argument that it has nothing to do and somehow is irrelevant to the questions before the court here.
well, it is irrelevant as to whether or not there was an aiding and abetting fraud, Judge, because this action is not brought on behalf of an investor. It's brought on behalf of the company. The company claimed that it had been defrauded by its own documents. There's no allegation that the company relied on any of these false statements. Look, later on, Derek Taller, who was the principal of the company, looted the company, but that had nothing to do with the representations in the PPM. Let's talk about the
Well,
representations. in the
but
PPM.
wait, it did have something to do, because if you don't have an auditor, then looting the company becomes a lot easier. If you don't have a board of directors that meets and discusses what's happening with the investments, it's easy to loot a company. So it is absolutely relevant, counsel.
It certainly is, Judge, but Mr. Lesson was there at the very beginning. He left in May of 2020, and that's
Is that an established fact that he left in May? of
Yes, it is an
2020?
established fact. In fact, there's a reply letter from from Vision's then attorney telling him you have had nothing to do. It's in the record at 460.
So why is he all of a sudden requesting?
The record wasn't developed, Judge, because that letter was foisted on us at oral argument. So I do note in a footnote that it was around the same time that Joseph Taussig was in a fight to take over Vision, but the record was really not established.
So, but according to this email, when he's requesting a special board meeting, he's doing so as what? As
Yes, Judge.
member of,
Presumably as a director, but the law firm writes back, you are not a director of the company. You terminated your relationship with the company of May of 2020. You have not had anything to do with the company since that time.
Well, he wasn't a director because there were no directors.
No, Judge, at that time, they had a new board. He had been replaced. There were directors at some point. There were other directors. There was a line of directors that followed him. Whether they met or not, Mr. Lesson can't be held liable for that at the very inception. Also, with regard to the breach of fiduciary duty causes of action, those were all time barred. Whether you apply the law of Puerto Rico under the...
But, I'm sorry, I didn't mean to interrupt. That is correct. I don't think they're disputing that this was a company established in Puerto Rico and with a technical office there. But on this record, or at least as we know so far, the headquarters were New York, where Taller was working from.
Yes, Judge.
And Mr. Lesson, your client, actually conceded and admitted that there were no other operations of Vision outside the jurisdiction of New York.
Absolutely, but they were still a non-registered foreign resident. But having said that, even under New York statute, there's not a blanket 6-year statute of limitations for breach of fiduciary duty. There's no actual fraud in connection with the breach. It was a Caremark violation, and that has to be alleged with a sustained and systematic course of conduct, and that wasn't here. And Judge, with regard to the names of the members of the boards of directors, the plaintiff conceded below that the initial incorporator, Anthony Raftopol, actually properly appointed those people in December of 2019. So I think it would be very hard pressed for them to show that Mr. Lesson first had any knowledge that it was contrary. And again, according to the laws of Puerto Rico, as interpreted by the courts in Delaware, he would have been able to rely on that representation. So what we're dealing with is one representation, if I can just conclude.
Finish.
One representation with regard to PricewaterhouseCoopers, and any investor would have known that a new company without any track record would be talking about those forward-looking statements.
Okay.
Thank you, Judge.
Okay, as in, I accept what you said, not that I agree. Yes. Just to be clear, I don't agree with you at all. Go ahead.
Thank you, Your Honor. Pardon me, I didn't mean to. Bill Katz on behalf of Vision Biobank Holdings. Let me start by dealing first with this statute of limitations argument. I think Your Honors have jumped right on that point. Paragraph 18A of our complaint explains that this business was headquartered in New York. That was its only place of business. As a technical matter, much like many corporations are founded in Delaware but operate elsewhere, for tax purposes, this was founded in Puerto Rico. Its only office was here. This is the proper forum, and therefore it was a resident, and therefore the 6-year limitations applies. This case in and of itself is a massive fraud committed by Derek Toller, and that fraud was only allowed to occur because of his right-hand man, defendant David Lesson, who was there from day one, not just for this company, but for Saint Health as well. And in fact, Mr. Lesson sued Mr. Toller and these various companies, alleging that they were all a massive fraud from the get-go because he didn't get his share of the ill-gotten gains when he and Toller had a falling out, and Toller didn't give him his piece of the action.
Anyway, on this record, there was a claim, your friend makes a claim that Lesson had nothing to do with the PPM. Not true, right?
That is not an established fact under this record. He is presented through in his opposition, or maybe in his reply, I'm sorry, it was his motion, I think it was in his reply. He presented metadata, which he claims, conclusively establishes that another person drafted the document. We all know what metadata says. It tells you who hit save on what computer. It doesn't mean that there wasn't a printed copy that this gentleman edited and played a massive role in.
But wasn't there another litigation, the Saint Health litigation, where he pretty much says, I was heavily involved in this?
Yes, and that is what we allege, and we point all of that out, that he was based upon his
marketer.
role in the company, he was the architect of that document, even if he was not the technical scrivener typing it out in the computer. If there aren't any other questions.
Can you have an aiding and abetting a fiduciary when you're the very fiduciary?
So,
And I
under
think
Delaware
we have,
law, there
we
were
have case law that says you can.
So there were 2 Delaware cases that we cited to in our briefing that addressed this issue. One is from a year prior, and one is a year later. And I think the second case is more of an exception rather than the general rule. And it goes into the point that the person was not a party to the partnership agreement and therefore could not be held as a direct fiduciary. And so it created this exception. But if you look at the case from a year prior, in which the person was a fiduciary, it's certainly logical that you could be a fiduciary while also aiding and abetting somebody else's separate breach of their own fiduciary duties, because they're not necessarily the same fact pattern. And here we
Sounds
have...
like a little legal gymnastics there.
It is a little bit of legal gymnastics, but in this case, I'm talking about the fact that there could be a direct breach of fiduciary duty by Mr. Lesson, as well as separate breaches of fiduciary duty by Mr. Toller and his other co-conspirators, of which Mr. Lesson, given his unique role in the company, set the stage for. I was trying to think of an elevator analogy. I'll just stick with my original, which is you got a rock at the top of a hill, you push it down the hill, and it knocks somebody over. You can't say, "Ooh, I left the mountain, so I'm no longer responsible for that." And in the case of the aiding and abetting, Lesson set the stage for all that, pushed the rock down the hill, and now wants to wash his hands of it. That can't be.
He left the mountain.
How do you address your friend's argument regarding how do you sue yourself?
Oh, sure. So this gets a little murky here. So my client, the current board of directors, is comprised of investors who were defrauded. We took control of the company, did not know of any of these actions, and so the notion that these are, the harm is to the company. The company's out $45 million. Investor money went poof. That's the company's money. The fact that investors may separately have direct claims or, in arguably fiduciary duty, derivative claims that they could bring about on behalf of the company. No, the company's directly bringing them by its newly constituted board against Lesson, Toller, and the folks who took that money and made it go poof.
You allege a loss in the complaint?
We do. There's $46 million that was invested in this company, 26
Who
of which...
invested the money?
Pardon me?
Who invested?
Derek Toller, the founder who is no longer involved in the company. So the loss is, and I don't mean to, if you were going to ask a question, there was an investment made to a company called Naha, It was a $26 million loan. It started at about 5, and then in the course of 6 months, it gets ramped up to $26 million, 68%, 60-something percent of this company's invested assets. They defaulted in less than 6 months, and what nobody knew until much later was Derek Toller was getting paid close to $1 million in fees and commissions and all kinds of side stuff from that company. That's just one example, many others abound. But the company's money is now gone. The company was harmed because of Toller and Lesson's misconduct.
How can you rely upon your own PPM?
It is, I understand where you're going with this. I didn't mean to cut you off, but the PPM is just setting the stage for the misconduct. The misconduct, the fraud, is making investments that had no colorable basis in fact, loaning to a $26 million to a company you were interested in, making off-thesis investments in Sam Bankman-Fried's, that whole thing. And the PPM is just what set the stage for that, because people would never have invested that money had they not believed that this was a legitimate organization because of Mr. Lesson's actions.
Thank you.
Your Honor, just briefly, there was no Saint Health fraud, and in fact, in that lawsuit, Mr. Lesson didn't claim that he wrote the PPM for Vision. He claimed that he wrote it for Saint Health. The other thing is, with regard to this concept that Mr. Lesson is responsible after being there for the very early time, and there were other subsequent boards, Vision issued revised PPMs in August and November of 2020, which said they didn't have an active board and that they were not going to have an auditor until such time.
And how much money had been invested in the company before the second PPM was released?
Judge, I think it was about $2 million. Now, having
Really?
said that, the loss is, again, not as a result of Mr. Lesson's role, it's a result of Mr. Taller stealing the money for his own purposes. So again, I know you have trouble with this, so he's been quite clear about that, but it doesn't relate to what Mr. Lesson did. And again, under Caremark, they have to show a sustained and systematic abrogation of supervision. And in that limited period of time, they don't even claim in their complaint that a meeting should have been held prior to June of 2020. He was out the door in May of 2020. And again, on the statute of limitations issue, they also, when they revised those PPMs, the company was on notice that the initial one was inaccurate, right? Those were aspirational. And as a result of that, the statute, 3-year statute, not a 6-year statute. No, you're laughing, so I'm not.
This one and this one and this one are on the board. That's aspirational. I'm sorry. Board director, no, that's not standard. When a PPM says these are the members of the board, those are the members of the board.
And they were the members of the board. The plaintiff conceded that below, that they had been properly appointed by the initial incorporator, who Mr. Lesson was allowed under
Yet they didn't know anything about it.
That's, again, the allegation isn't whether it's an active
Amazing.
board.
I'm on the board, but nobody told me.
And
I mean,
this is a
that's what
motion.
we have here.
This is a motion to dismiss. So,
Yes, it's a
so
motion
we
to
haven't
dismiss.
had really any discovery here.
Correct, Judge, but with regard, again, to the fraud and the statute of limitations, I think those are ripe for decision. You may say, oh, we need discovery, but on the fraud, there can be no set of facts in which Vision itself relied on a false statement to its detriment and suffered harm. That goes back to when Judge Rapallo was on the Court of Appeals. So that's not a new concept.
Thank you.
Thank you, Your Honor.
Barelick versus Mary Manning Walsh Nursing.
Good afternoon, Your Honors.
Good
May it
afternoon.
please the court, Scott Horn, counsel representing the appellant in this matter. It's our contention, Your Honors, that the motion court erred in awarding a pre-answer, pre-discovery dismissal based upon defendant's EDTPA immunity affirmative defense. As this court recognized in Thomas, the immunity defense requires a fact-intensive inquiry, which in the absence of discovery is premature to resolve as a matter of law. After Thomas, and as this court recognized and held in De La Rosa, the record herein does not conclusively establish defendant's entitlement to immunity because questions of fact exist concerning both defendant's ostensible good
How do you
faith.
get around Hassan? Hassan, according to your friend, is on all fours. Whether or not you like it or not, it's a case that came out and went against the precedent you're citing.
Well, Hassan was decided pursuant to 3211A1, not pursuant to 3211A7. So I would submit that that procedural footing shifts the analysis. After Hassan was decided, this court has released a series of decisions, not just Holder, not just Jackson, but more recently, Thomas and De La Rosa. And these are the precedents that we submit should be applied in this context on 3211A7.
Isn't it true those cases are distinguishable? It talks about the bed sores, it talks about other ancillary issues, not necessarily a direct service related to COVID. It's indirect.
Well, Thomas is a COVID nursing home case. I agree that Holder and Jackson are hospital cases involving non-COVID injuries to a certain extent. But more recently, here in De La Rosa, this court recognized that a citation from the Department of Health was indicia enough to create an issue regarding good faith.
But in this case, excuse me, in this case, while you make reference to 16 alleged citations predating 2020 and post-dating 2020 in 11.1, 11.2 of the record of your complaint, you do not particularize any of those citations as to any linkage to infection control. That's clearly absent from the record, yes or no?
Yes, that's correct, Your Honor.
Okay,
So the allegations...
and moreover, while you managed to draw inferences from an analysis of financial records to show diminished staffing or inadequate staffing, at least on this record, from at least 3844 to 3860 something of the record in terms of the decedent's care, there's no information here that suggests any inadequate care. Certainly nothing that I saw in reviewing the daily records by the nursing staff and the doctor that showed that the decedent was not adequately being treated since she got the infection.
There's two things that I would say in response to that. Number one is that while their medical records do indicate that the individual was being cared for, of course, the person wasn't just left in a room on their own, there were large gaps of time evident in those records that have not been explained. Secondly,
but you didn't have any testimony here. All you have is the doctor claiming inadequate staffing, and you didn't counter the fact that the Mary Manning Walsh had third-party staff coming in. This is in the middle of COVID. It just started. It's March 20th when the governor's orders were issued through when, and again, I'm sorry for the loss, when the decedent passed away as a result of COVID on March 31st. Having been stable throughout that period until March 31st, where she decompensated.
March 25th is when it started.
I know exactly on 3844 of the record. I know that.
But I think that you made my point for me when you said that there's no testimony. We're at a 3211 pre-discovery, pre-answer stage. Of course there's no testimony. And moving beyond that, we submitted an expert who looked at those very same records that Your Honor looked at and said there wasn't a proper infectious control protocol policy in place at the nursing home, and in fact, it predated COVID, led into COVID. And the second expert report, these reports are, I respectfully submit, significantly dissimilar than probably any other COVID case that's come before this court. If I may just finish up this point. We have directly tied in concepts of purposeful understaffing for financial gain, which was precisely what the Office of the Attorney General referenced in her report, that there were financially driven decisions rather than clinically driven decisions. And the way that it came to bear here was that they reaped these millions of dollars in savings and being understaffed. And the Attorney General's report also highlighted that understaffing was the most indicative element of death rates that there was, even more so than geographic area.
Thank you.
So, thank you, Your Honor.
And now you're going on a speech. Okay, come on.
Good afternoon. May it please the court. Megan Lawless, counsel for the defendant respondent.
Counsel, that Attorney General's report, did it Was it specifically as to this particular nursing home, or was it in general as to nursing homes in the state of New York?
It was general as to nursing homes in the state of New York. And it talked about the financial motivations behind bad actors in the state of New York. And as pointed out in our brief, this is a nonprofit nursing home. This is part of the Archdiocese of New York's continuing care community. And the expert reports in this case talk in generalities in terms of intentional understaffing. And nowhere in those reports do they talk about the impact of the COVID pandemic on staffing, or in any way this particular facility's potential understaffing. It doesn't talk about their infection control protocols at all. There's no specific mention in these reports of this patient's care, of her medical course, or the infection control protocols in place.
Well, in fairness to the plaintiff, this is pre-discovery. So they're operating with, and unfortunately the plaintiff's decedent passed away, and so she's not there to provide any insight, and so they're left with whatever firsthand information they may have, the family members, and the medical records. So they're operating with not a full deck here in opposing this.
Well, with respect to this motion, the motion papers included the infection control protocols and the affirmations of two individuals from the facility, the chief nursing officer, as well as one of the treating physicians. So presumably the experts had that information available to them in formulating their opposition to the motion. They had the medical records. There were 3,700 pages of medical records. Within those expert affirmations, there's no discussion of this patient's care.
Counsel, why isn't there at least an inference that can be had from reviewing the two experts of plaintiff, wherein the damage expert reviews the records of the nursing home and finds millions of dollars worth of savings that would at least indirectly attribute to the lack of staffing, which on a 3211 motion should be considered as true for the purposes of the motion only?
Well, again, with respect to staffing, it's an exception to the exception under the EDTPA. You know, insufficient staffing cannot be a basis for gross negligence given what was going on in the pandemic. And again, as the court recognized, this was the end of March to early April, the worst of the worst, when there was so much unknown and it was still being discovered. And this patient was tested and treated the day her symptoms developed on March 25th. She was stable throughout until her symptoms worsened on March 31st, and she passed away within 24 hours.
I'm sorry, is there any indication in the record whether there was any change in staffing levels comparing pre-COVID with COVID?
Specific staffing levels in the facility at the time, no. There was just the affidavit of the chief nursing officer who talked about staff absences, changes in staffing, having to bring in agency nurses, but documented day-to-day, no. But again, it's just one aspect of the impact of this patient's care.
My recollection was that there was a decrease in staffing, according to the expert. That's what gave rise to the millions of dollars of savings. Otherwise, the math doesn't work.
Well, it's not surprising that there would be a decrease in staffing
Correct.
during the COVID times.
I thought you denied that there was a decrease in staffing.
No, I'm not
I
denying
misunderstood. I apologize.
Yes, no, I'm not denying it. I think just in summary, this case is no different than Hassan. The controlling facts are the same. The underlying evidence is the same, as well as the collection of cases out of both the second and the third department, which have all affirmed dismissal.
No, counsel, I believe the second department has gone the other way. I thought that there are at least three to four cases where they found it was premature, and I think it's cited by your friend.
In all of those cases, the evidence submitted was found lacking. And when I say found lacking, in most of those cases, and this is cited in our brief with links to the record, there was the briefing and law. There was no affidavits, there were no medical records, there were no protocols. And that is Burke, Ho, Garivia, Gonley, there's a collection of them, Sterlacci. There was no evidence. In this case,
I thought in those cases it was similar in that, you mind? It was similar in that there was an affidavit from a nurse, an affidavit from a doctor, and there were medical records. And they may not have been the full medical records, just like we don't know because discovery wasn't done whether the full records are here as well. But my recollection, it was not based only upon speculation. There was supporting affidavits and medical records in all those cases.
The cases in the second department, similar to this in terms of the full body of evidence, is Piero.
Can you correct me and tell me, were there affidavits or affirmations in support of the second department decisions?
I believe there is one case in the second department that had a 5-page affidavit,
Other than that one, there were others that had more than that.
not in the nursing home context. Piero, Lara, Costiera, Byington, most recently Burl, which is not briefed, all had the same type of evidence that was here, and the second department affirmed or reversed and dismissed those cases.
Thank you. We'll take a look.
Thank you.
Your Honor is correct. There is a raft of second department decisions, which I personally handled, that have affidavits.
Did you put in medical records?
Absolutely.
That's what I thought.
And affidavits, multiple 10-page affidavits in the cases of Burke, Gavira, Ho, and Lee in particular.
I reviewed it.
There's a raft of cases involving affidavits that were rejected by the second department. And
To
we
be
respect.
fair, the medical records were not as, were they the same like we have here?
Absolutely.
They were?
Yeah. There's minimal differentiation between those affidavits, particularly in the ones that I just mentioned.
Not affidavits, medical records.
Medical records, some of them are extremely large records, some of them are smaller.
Okay, that's to be fair.
Yeah.
Thank you.
But to say that those cases all rest upon the notion that there was no affidavit, there is a line of precedent in that regard, but it's not those cases. So in the second department, the way that this evolved was first they planted the flag on, if I may just finish this point.
Yes, but let's not belabor it too much because
No,
we're in the first department and we're following our cases.
I understand that.
All right,
So
go ahead.
there was a line of cases with absolutely no factual affidavit. That was followed up with about 5 cases, including the ones we just discussed, which did have factual affidavits, which found in favor of the defendant and allowed discovery to go forward in a situation where it's 3211A7. We respectfully submit that that's precisely the result that should attend here.
Thank you.
Thank you, Your Honors.
A good one. People versus Jeffrey McCavey. You may proceed.
May it please the court and good afternoon. Daniel Schumeister on behalf of Mr. Jeffrey McVeigh. In People v. Baines, the Court of Appeals held that colloquy courts, quote, should explain to the defendant the court's rules regarding the role of a legal advisor or standby counsel and how that role differs from representation by an attorney. Because here, as in Baines, quote, no such explanation was given, again, that's Baines's language, the waiver was invalid.
But in Baines, didn't the court caution against brief, generalized warnings? Here, I thought the court followed the CJI model colloquy, or at least substantially followed it.
That certainly is an aspect of Baines, and there were 2 issues in front of the court in Baines that made the colloquy invalid. There was the short generalized nature of the warning there in that case, but there was also the lack of any explanation regarding the role that the legal advisor was meant to play. And there was no explanation provided here whatsoever to Mr. McVeigh regarding what the legal advisor was going to do or was not going to do. The court told Mr. McVeigh he's not your attorney, but of course, there was no affirmative explanation as to what the legal advisor would or would not do.
So following up on what my colleague has just stated, in reading Baines, the court said that the record there was a little more deficient because it said the court's record exploration of the issue did not warn defendant of the risk of proceeding pro se or apprise him of the importance of a lawyer in the adversarial system, which the court did in this case, nor does the record as a whole demonstrate that defendant effectively waived his right to counsel. So there, the court didn't go as far as the court did here. I mean, it was a 20-page, basically, colloquy that the court had with this defendant, telling him about he's not qualified to represent himself. uh, inquired as to his level of education, inquired as to, warned him that he was going to have to do certain things for himself that his lawyer would be capable of.
Certainly, Your Honor. There was a lot to the colloquy, and in many respects, the court did announce much of what is within the model instruction. But there was nothing provided in this key issue regarding what the legal advisor would do. And that is an important piece with respect to whether Mr. McVeigh understood fully the risks inherent.
Had Mr. McVeigh told the court that he could represent himself because he had done so before?
Mr. McVeigh had a...
Am I recalling this correctly? I've had a lot of criminal cases. So did he say that?
Mr. McVeigh did tell the court that in a 2014 Suffolk County case, he had a legal advisor. That was a plea case about a full decade prior to this.
Yeah, but it was in Suffolk County. That not the same as Manhattan, right?
I did previously practice in Nassau, not Suffolk. So what I will say is that...
Same difference.
What I will say is that there is no information provided to Mr. McVeigh.
So he was familiar with the legal advisor because he had one previously, right?
Not in the most important respect, which is what was this advisor going to do at trial? Was the advisor going to give solicited advice or unsolicited advice? This comes up in other of the cases we discussed, such as the Hiltz case from the Third Department, I believe, where the legal advisor was told not to provide any unsolicited advice. Was that going to be the situation?
So it's not enough for the court in the midst of the colloquy to make reference to the legal advisor. There had to be an explanation as to what exactly that means. There's a lawyer, there's a legal advisor. This would be the role of the legal advisor, because the court here did make mention of a legal advisor.
Correct, Your Honor, exactly. The court mentioned that Mr. Sharp was going to be the legal advisor, but there was no explanation provided whatsoever as to what the advisor was or was not going to do.
So if the court says to him, you're going to have to examine witnesses, you're going to have to cross-examine witnesses, you're going to have to sum up, you're going to have to make an opening statement, isn't that basically saying it's all on you and your legal advisor is just there if you have a question?
Well, of course, Mr. McVeigh, like any other layperson, doesn't know the full extent of everything that might go on at a criminal trial. He cannot be assumed to know that, well, everything that the court has not mentioned is going to be for the legal advisor to do, because...
But you're not suggesting that the court has to tell a litigant who wishes to go pro se every single possible eventuality that might end up happening in a trial. That's impossible. Can we agree on that?
We can absolutely,
that's impossible to do.
We can absolutely agree on that, and
Okay.
if I may,
Yes.
What is most important is that the core responsibilities of the legal advisor must be provided and explained to a defendant like Mr. McVeigh. There does not need to be a full catechism. We accept that those statements from the Court of Appeals are there, but there must be an explanation as to what the advisor is not going to do. And I do think that two of the core ways in which that must be explained are whether he's going to provide any solicited or unsolicited advice, which way is that going to go? And also, is there going to be a difference, for instance, between the way the advisor acts outside of the presence of the jury versus in the presence of the jury? So for instance, at a suppression hearing versus when the jury is there during the trial itself. How is this all going to work? Mr. McVeigh received no such explanation from the court, and so a reversal is required.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. Addison Esley for the people.
Why is your friend wrong that the failure to give more explicit explanation about what the role of the legal advisor would be, why isn't that an issue of reversal?
It's
level?
simply not the Court of Appeals holding in Baines, Your Honor, to require such a thing. The Court of Appeals in Baines, as Your Honor pointed out, addressed the sufficiency of the colloquy itself in being a searching inquiry, and only after it held that the colloquy in Baines was not sufficient did it, quote, note that the court should explain the role of a legal advisor if it appoints one. It uses language that it is noting that it should. It is perhaps better to explain the role of a legal advisor than not to do it, but that does not mean that it is a requirement of a valid colloquy.
So we're going to ignore what the Court of Appeals said, that it should?
You're not ignoring the Court of Appeals, Your
How
Honor.
are we not ignoring it? There was
because-
no explanation of what this a legal advisor, What does that mean?
So here, Your Honor, first I want to say that that line in Baines is dicta. It is not essential to the holding in the Court of Appeals case in Baines. And so that is not binding precedent on, it is language from the Court of Appeals on guiding a colloquy, but it is not itself language essential to that holding. And second, there's nothing in the record here indicating that Mr. McVeigh waived his right to counsel under any sort of understanding of how the legal advisor would play a role in his trial. The court walked him through the full model colloquy.
Well, the court gave him that of their own accord. So how could he have been expected to ask a question? You don't know what you don't know. So how does he know to ask that question before the judge says, oh, by the way, I'm going to give you a legal advisor?
Well, he could have spoke up, Your Honor, and at the end and said, I don't understand what the role of this legal advisor would be.
So now you're saying that the obligation is on the defendant who is being questioned about whether they have the capacity to represent themselves. You're saying in that scenario, we should hold that person to the standard of know what questions to ask? Or that you should ask a question?
I'm saying, Your Honor, that the court here needed to conduct a searching inquiry to understand that defendant understood the pitfalls of representing himself. That is the standard for a waiver of right to counsel.
Let's say I agree with you that in terms of that, the judge got it right. But now the issue is whether the judge had to go further in their explanation about what does it mean that you just gave me? You give me a gift and you don't tell me how that gift works.
Well, as
right? The judge gives the defendant a legal advisor and doesn't tell the defendant how it works. Why is that not a problem?
Because the role of a legal advisor, Your Honor, is so amorphous and varies case by case. And as you pointed out, it is impossible for the court to tell the defendant of every potential possibility of how that legal advisor would act.
But I guess that sort of begs the question, right? Because now, under Providence and the like, the court's core responsibilities in conjunction with the searching inquiry are to make sure that the defendant understands the risks inherent in going pro se and understand the singular importance of the lawyer in the adversarial proceeding. And so now if you are, the court, well-intentioned as it may be, interjects the legal advisor, now are you sort of undercutting the potency of the warning? If you go without a lawyer, you run all these risks. Now I'm interjecting this legal advisor if it's not made clear to the defendant what the role is. Even just to tell them the role is amorphous, is that sort of watering down the warning of look at these dangers of going pro se?
I don't believe it does, Your Honor, because the court here told the defendant, you will be responsible for all of these things, and I am appointing a legal advisor. He is not your lawyer. And as Your Honor pointed out, that implies to him that that legal advisor is there to answer questions for him, whereas the court's language that defendant will be responsible for these myriad tasks at trial, that then leaves the task of the legal advisor to simply advise. And the defendant in that position would hear the court's language of you will be responsible for all of these things. I'm appointing a legal advisor. He's not your lawyer, to then be that the legal advisor's role is to advise. And as your honors have said, it's simply unworkable for the court to then have to lay out exactly how this legal advisor would respond in every potential scenario. And I'm happy to answer questions on the other issues, Your Honors. Otherwise, people ask that you affirm. Thank you.
You have 2 minutes.
Thank you. Your Honor is exactly right. The obligation is not and cannot be on a layperson like Mr. McVeigh, who's looking to go pro se, to know what questions to ask so he knows exactly.
Did the Court of Appeals in Baines actually say that the court needed to explain to the defendant the role of the legal advisor? Or was this just like was said before, dicta, something that maybe the court should take into consideration as opposed to must, has to?
Your Honor, this is not dicta. The people brought out this argument in their opposition. And as we note, when the Court of Appeals wants to provide a better practice, and a possible way for a court, the best way for the court to do that's not mandatory, it knows how to do so. It did so exactly in People v. Silburn, another pro se representation colloquy case. It did so in People v. Rodriguez from 2000, again related to pro se representation, that one regarding motion practice. And in this case, they provided no such information, no such statement that this was just a best practice that was qualified as something that the courts did not need to do. Instead, it stated the rule, and not only that, the court applied the rule. No such explanation was given here.
Yeah, but are you suggesting that they articulated a brand new rule? Because I see a pattern here. There's a pattern, say, with Boykin rights or waivers of appeal, or in this case, the right to self-represent. You don't have to check every single box based on the totality of the colloquy. And as was pointed out, you had 20 pages in this transcript where they walked through the model colloquy for him to be competent or for the court to find your client competent to represent himself. And he threw in a gift, as my colleague pointed out. So maybe the better practice would have been to discuss the legal advisor, but based on the totality, the court did a very thorough job of affording your client the adequate warnings and findings that were necessary for you.
If I may.
Yes.
In this case, when we do look at the totality, this is a situation where the waiver cannot be valid because this essential element of what had to be explained to Mr. McVeigh was absent. And to the extent anything else is required, there were also the other egregious errors that the court made that we would urge this court to look at as well with regard to the explanations to Mr. McVeigh regarding what he had to do regarding witnesses and evidence. And for those reasons and the reasons in our briefing, we ask that the convictions be reversed. Thank you.
Thank you. What's the name? You know I can't say it. Rudakevich versus 164 West 79th Street, and I thank you for your assistance with that.
And I might not even be right, Your Honor.
Well, you're better than me, I'm sure.
Good afternoon.
You may proceed.
Peter Riegelhaupt of the Parisman firm for the plaintiff appellant respondent Nick Rudakevich. Clearly, plaintiff met his prima facie burden, so the only issue is whether the sole proximate cause defense is applicable, and it's not. There's two bases that my friends advanced for the sole proximate cause defense. As to the scaffold, nobody ever instructed plaintiff to use a scaffold. Everybody agrees that, including their expert, that the ladder was the appropriate device for the job. Plaintiffs...
And there's nothing in the record by defendants that the plaintiff was instructed to use a scaffold and for no good reason chose not to.
That's correct, Your Honor.
Okay.
The fact that plaintiff testified that he would have preferred a scaffold and evidently was mistaken as to the existence of the scaffold doesn't alter the analysis, because the Court of Appeals has said Zimmer, this court in Aramburu has said that, the statute imposes an unvarying standard without regard to any external considerations like custom and practice or someone's preference. So the fact that plaintiff said that and was mistaken doesn't change the analysis at all, and certainly doesn't rise to the level of sole proximate cause. And by the way, the only evidence of the scaffold is the photograph that Strandberg submitted with his affirmation, which he said was taken at or about the time of the accident, and it's in pieces in a closet. So now you're imposing the burden on the plaintiff to put it together, set it up, and use it.
And we have case law that says a plaintiff doesn't have to go searching a construction site for the equipment he needs to be safe.
Of course. So that takes care of the scaffold. So now let's get to the garbage bags and the manner in which plaintiffs set the ladder up. Obviously, this court has said on numerous occasions the manner in which a worker sets up the ladder really only rises to the level of comparative fault. In this case, I don't even think you should consider Dragani's testimony.
Why is that?
Because it's unbelievable as a matter of law, frankly. He has said that 2 legs of the ladder, and I was looking at this earlier, and I think this is probably 18 inches. He said 18 to 24 inches high. 2 legs were, the right legs of the ladder were 18 to 24 inches higher than the left legs. I don't need an expert to tell you. All you have to do is ever climb. You don't even need to have ever climbed the
would be
ladder.
pointed that way.
The minute he stepped on the ladder, if that were the case, it would have toppled over. And Dragani said he had his eyes on him for 5 to 10 minutes. The ladder's moving. It's just a physical impossibility. And beyond that, you got a guy, Dragani, who's, while he may not have had any supervisory role over the plaintiff, he testified he's versed in ladder safety. He's watching this guy on a ladder working in that fashion with a cordless driver in one hand and a 4-foot piece of ductwork in another, and he doesn't say anything to him. He doesn't say, get one of your coworkers, those many unidentified coworkers. He doesn't say, get one of those guys to hold the ladder. And all of Dragani's testimony, that's not in a vacuum. You have to remember that he also said no ambulance came to the scene, and he went down the elevator with the plaintiff. We have the certified record in the hospital, EMS record in the record. They came, they found him on the 10th floor, lying on the ground, having fallen from a ladder. So neither of those bases rise to the level of sole proximate cause. I guess there's a third issue that was raised that I'll address, that Strandberg says they thought the accident might have been staged. I don't understand that argument because Dragani said he watched him for 5 or 10 minutes on the ladder. And he saw the accident happen. So I don't know what Strandberg was trying to say.
Well, he said
in
he
that.
fell sort of like in slow motion. So maybe that's what they're talking about?
Your guess is as good as mine, Judge Mendez. Strandberg certainly didn't explain it in his affirmation, but beyond that, the guy tried to go back to work after the accident. The boss of the company described him as a great worker, diligent, intelligent.
But he was about to get fired because of the delays that they were having on the job.
Well, there's a dispute as to that. They say he was demoted 2 days before the accident, so that's presumably, why he staged the accident. But if you try to go back to work after an accident of this magnitude, that's not indicative of somebody who's staging an accident for presumably secondary gain.
Thank you. You may proceed.
Yeah, much shorter. Okay. Good afternoon, Your Honors. May it please the court. Lauren Turkel for third-party defendant, respondent, appellant, Wath Built Works. The motion court correctly found in rendering its decision that plaintiff failed to establish that the ladder, which he set up, declared to be without defect and in stable condition for the 15 to 20 minutes he used it just prior to the accident, was an inadequate safety device. To the contrary, the record shows that the ladder and Baker scaffold were adequate safety devices available to the plaintiff.
Scaffold was in a closet, unassembled. So that to me is a red herring. And there's nothing in this record, and correct me if I'm wrong, where any of the defendants directed him to use a scaffold and he chose not to do so.
Yes, Your Honor, that would have been impossible because plaintiff was the person in charge of directing the safety devices at this job site. It was also a residential apartment.
I thought he had been demoted 2 days before.
He was still the
So how can he be the safety manager and having been demoted 2 days before?
Yes, he was told that he was no longer going to have that role. He was still, by his own testimony, we'd have to discount that as well, the person in charge of delegating the safety devices at this site, that there was a scaffold available.
So this argument was made recently in another appeal, this very same argument. So are you suggesting that the labor law protections don't apply to a worker who has been designated the site safety manager, person, whatever?
Absolutely not, Your Honor.
Okay, so good, I'm glad, because then the fact that he's a site safety manager and is giving out equipment is irrelevant. The question is whether he was provided with proper equipment.
Yes, and the motion court correctly found that he was, both the ladder and the scaffold. Plaintiff testified, despite the fact that this was a 3-bedroom residential apartment. It was not a large-scale ground-up construction, that there was no Baker scaffold. That was his claim, that it would have been his, quote, preferred device, but that he didn't have access to one. And so that is why he used the also adequate ladder, which allegedly was rendered temporarily inadequate for reasons that only Mr. Dragani can explain before it became appropriate again because the ladder remained in service and continued to be used. What you have is the scaffold present in the apartment, despite plaintiff's claims to the contrary, authenticated in a photograph, which my friend says was provided with Mr. Strandberg's affidavit. That photograph was exchanged multiple times throughout the pendency of the litigation. What Mr. Strandberg did was authenticate the previously exchanged photograph. It wasn't a new piece of evidence. He authenticated
Counsel,
a piece of
did
evidence.
anyone tell the plaintiff that they were required to use that scaffold?
The record does not suggest, because plaintiff admits he was responsible for delegating the safety devices. I apologize.
Mr. Strandberg or the other person, I forgot, Regani, tell the plaintiff that you must use a scaffold and not the ladder?
I don't believe that was necessary in this case.
So the answer is no?
So the testimony
Wait a
regarding...
minute, so the answer is no?
The answer
And
is
no one told him he had to use a scaffold?
no.
Okay.
So regarding the scaffold, because that's what we're discussing right now, there was one witness that testified regarding the scaffold and said that it was brought in for the painters to use. And he did not know if any other workers used that scaffold. So it was not actually brought in for, and that was, I think, Mr. Schema, S-K-E-M-A, and his testimony is at 741 to 43 of the record. He did not know if any of the other workers working at those premises were to use the scaffold. So it was brought in for the painters.
It was brought in as part of the safety equipment for Roth's employees. And
That's not what he said.
well, it was Mr. Schema and Mr. Strandberg confirmed that the Baker scaffold was there and available for use, and Mr. Schema did testify to that.
Mainly for the painters. And they did not know if any of the other workers use or could use the scaffold.
Plaintiff was not just any other worker. Plaintiff was the person delegating the safety equipment and the person with the first authority to say what equipment was delegated to him. I think also the other issue here is the adequacy of the ladder, right? We've got, may I finish, Your Honor?
Yes.
We've got an unwitnessed accident.
That's not required, right?
Of course. This is just the first finger I'm putting up in my fingers. We've got the unwitnessed accident with a witness who is inconsistent with that as to how this accident occurred. And we've got a plaintiff here talking about the adequacy of that ladder, that it was defect-free. And we've got Mr. Schema and Mr. Strandberg confirming that after this accident, there was nothing wrong with the ladder. It was not taken out of service.
I think our case law is replete with cases that say the ladder doesn't have to be defective. If the ladder doesn't protect the worker from falling, it's a 240 sub 1 violation, right? So a ladder could be perfectly in great working order. If it's not secured and it could tip over, flip back, then it is a 240 sub 1 violation. This man was on a ladder with a pipe in one hand and a drill in another on an unsecured ladder. That's what we have here. But you'll have time on rebuttal.
Okay, thank you.
Good afternoon, Your Honor. Sean Schatzel of Lewis Brisbois, appearing on behalf of the defendants, respondents. Briefly, Your Honor, on the painter issue that you mentioned, I just want to clarify on that. You're right, it's 741 on the record, it's Schema. But what he said was, he says there's a Baker scaffold on site. Yes, how do you know that? And he says, I purchased it for this project and other painters were using it. So I just want to clarify that he didn't say, this was just for painters, not for carpenters. He used that as an example of people he saw using it to explain why he knew the Baker scaffold was on site. I'd like to talk about the garbage bags, okay? So Dragani testified that he observed this man on the A-frame ladder, was leaning off to the side. I think there's really no dispute here that that's plainly an improper use of an A-frame ladder, okay? And as you heard plaintiff's counsel say, their opposition to that is you should simply disregard Nick Dragani. And I don't think that's appropriate.
That what?
That you should disregard Nick Dragani. That's what counsel said, that you should just simply disregard this testimony at the summary judgment stage. They offer various reasons for that in their brief. The one I heard here most mentioned
What was
was
his role in this project?
he was the resident manager for the condo. He actually,
So one would presume that as the resident manager for the condo, he would care that a worker is on a ladder that's leaning to the right on top of garbage bags, and he says nothing?
so a few points there.
That's really interesting, right?
I think that's perhaps a compelling argument in front of a jury, a closing argument.
No, you know what's compelling about it is that even if it were true, how does that not just constitute comparative negligence, as plaintiff's counsel said? So if it's true, let's say it's true, that the worker, the plaintiff here, stupidly put the end of the ladder on top of garbage bags, right? The ladder was still unsecured, right?
That's sole proximate cause.
And there
Your Honor.
was no one, no. Before we get to sole proximate cause, you have to give me a secured ladder. Do I have that?
If he didn't put it on top of the garbage bags, it is secure.
No. Secured doesn't mean opened up and locked. Secured means it is tied off to something, or there's another worker holding it so that it doesn't shift.
It's shifting on if you take Dragani's testimony as true, and I think we have to for summary judgment purposes, it is shifting because the plaintiff placed it on top of garbage bags and shouldn't do so. And I'd like to flag some precedent here, okay? There's Weininger from the Court of Appeals cited throughout our brief. That was a sole proximate cause case because the plaintiff was standing on a crossbar of a ladder. And even better for us, I think, Santiago and Meade are A-frame ladder cases like this case, where the plaintiff had it in a closed position and was leaning up against the wall. And the plaintiff's misuse of the ladder, when he or she did not have to use it that way, was the sole proximate cause.
So if we have garbage bags, we have a lot of garbage bags on site, and the only way that the plaintiff can get to the area where he's working is by having to place part of the ladder on top of a garbage bag so that he can reach, and this causes the ladder to be unstable, and he falls and gets injured. Do we have a 240?
If Your Honor's hypothetical were the facts of this case, I would agree. You said if that was the only way for him to do it, and if that was the circumstance.
Isn't that the case here?
I do not think so, Your Honor.
Because Dragani said that the garbage bags were in his way. He couldn't place the ladder in a proper way. He placed it on top of the garbage bag. I don't know how high.
Sure.
Because that was the only way that he could get as close as possible to the area that he was working in.
So let me respond to a couple of points, Your Honor.
That's at 618, by the way.
Okay. So on the 18 to 24 inches point, right? He said probably.
Well, now it's 24?
He said
it's
18.
growing by the,
No,
by
Your
the
Honor,
minute.
Your Honor, he said a foot to a foot and a half, and he said probably. But just to answer Your Honor's point, okay? Strandberg, the Roth project manager, 788 of the record, says the bags were easily movable by a single.
He was not there He was not there when this happened.
I mean, I think this is a question of fact for the
He
jury.
was not
But
there.
beyond that, also, Your Honor.
And the testimony was that there was garbage bags all over.
He was there before the accident, and he was there after the accident. And he says they're easily movable. And I'd say this court's decision in Egan, which was a sole proximate cause case cited in our brief, one of the things this court pointed to in terms of sole proximate cause, there was a scaffold in that plaintiff's way that had to be taken down before he could get his ladder into place. This court criticized that plaintiff for not dismantling that scaffold and not asking his supervisor about how he needed to do so. So in this case, we have some garbage bags and that he could have moved on his own if you accept Strandberg's testimony. If you don't, maybe he could have spoken to a few people, and he should have done that. His normal and logical response was to do so. He failed to do so, sole proximate cause.
Thank you. You have 2 minutes.
Regardless of what plaintiff's role was on the day of the accident, Strandberg was his project manager. He was really the guy that was in charge, and he was there that morning. He gave no instructions whatsoever to plaintiff. He didn't tell him to use a scaffold. There's no instruction, and there's certainly not one that he disregarded. And Strandberg also didn't, if you read his affidavit carefully, you're right, Judge Mendez, he wasn't there. He does not say that he ever observed garbage bags, either before or when he comes back after the accident. What he's saying is that I was told this by unidentified workers. And that's a real problem in this case. And they were very indignant about me bringing that up, that it's, 10 years after the accident.
Wasn't there testimony by the plaintiff that he cleaned the area before using the ladder?
That was plaintiff's
301 to 302 of the record, right?
Correct. That was plaintiff's testimony.
That's what I'm saying. So he cleaned the area. So going back to your point that Mr. Dragani could have been somewhat incredible with his affidavit.
I think so. But even if you want to accept his testimony, it still doesn't raise any question of fact. Because, as Judge Mendez pointed out, Dragani also said plaintiff couldn't reach the area because of the existence of the garbage bags. But again, I think really Dragani's testimony is just unbelievable as a matter of law. You can't have a ladder where two legs are 24 feet higher than the other two, and it's not going to topple over the minute you step on it. It's just impossible.
"24 feet, so the ladder has really grown. But
4 feet.
yes, it's one big ladder.
From 18 inches, 24 inches, to 24 feet.
Keeps growing.
Yeah, it's gonna hit the dome now.
It's on the roof.
Go ahead.
Yeah, I was just going to point out, as Your Honors say, that at a minimum here, what we're dealing with is questions of fact regarding how this accident happened. Plaintiff claims it was a debris-free concrete floor and that he provides no explanation whatsoever for why the ladder allegedly moved, which
It's called, I have a pipe in one hand and a drill in another, and I am reaching into the ceiling. Do you understand how unsafe that is if the ladder is not secured or being held by another worker? That's why he needed a scaffold, because a scaffold has a platform that he could stand on and doesn't have to depend on a third person.
Yes, Your Honor. I would just note that nearby in the same apartment was a scaffold. It was not assembled. It was present.
And he wasn't directed to use it.
And in DeRose, this court found that plaintiff was entitled to 240 because he fell off a ladder that shifted, and that plaintiff had testified that he was on his way to get a Baker scaffold in another area of the job site when his foreman stopped him and said, no, you have to go use the ladder. In that case, this court found that the issue wasn't the adequacy or inadequacy of the ladder as a safety device. It was that he did not have access to the Baker scaffold that he wanted to use. In this case, under the DeRose logic, plaintiff would be found to be the sole proximate cause because whether or not the ladder was adequate or inadequate, there was the Baker scaffold that was not obtainable.
I don't know how you make that jump, but okay.
But under Gallagher, doesn't the safety device have to be readily available? And so if the device hadn't been assembled, if the scaffold hadn't been assembled, could it be readily available within the meaning of the sole proximate cause law?
Yes, Your Honor, I believe it would be because it was not in another area in a large-scale construction site. It was not a scaffold that is erected above a sidewalk shed outside of a building. We're talking about a Baker scaffold in a closet in a residential apartment that was under construction. Thank you.
Bent versus 99 Jane Street condominium. You may proceed.
Good afternoon, Your Honors. May it please the court, John Delaportis for the plaintiff, Bruce Bent. We're here today seeking partial reversal of the court's decision below, which was a pre-discovery dismissal under 3211 of all the claims that my client filed against the individual defendants as opposed to the board as a board. We're not seeking, the court dismissed and didn't dismiss some of the claims with respect to the board itself. We're not seeking to challenge any aspect of that decision. So simply the first 4 pages of the decision are what's on review today.
In other words, essentially you want to have your alleged direct claim of tortious conduct to each of the individual board members, and they should not be shielded by the otherwise shield of being a board.
That's correct, Your Honor. We maintain that under Justice Acosta's decision in Fletcher and several cases subsequent to that, that the corporate shield applies to contract claims. It does not apply, certainly not to intentional tort claims, which is what we're alleging here and what we've pled with particularity. Justice, we're going to acknowledge that there's some competing lines of cases there, and the reason we maintain that Justice Acosta's line of Fletcher's correct is that one, it's been filed, we believe, in the majority of cases, and two, it's just consistently correct, and he explains why the competing line with, I think it's the Peloton case, is incorrect, which is that those lines of cases failed to distinguish between the corporate shield that Your Honor mentioned for contract cases versus intentional tort cases. And what Fletcher says quite clearly is there's no principle of corporate law that director liability arises only where the director conducts a tort independent of the tort committed by the corporation itself. A director may be held individually liable to third parties for a corporate tort if either participated in the tort or else directed, controlled, approved, or ratified the decision. In fact, if board members can all get in a room, close the door, and agree amongst the five of themselves that they can do whatever crime they want against the people who live in their building, then that would be an extraordinary finding of the New York law, and we don't believe that any court ever meant to give such a broad and sweeping immunity. Now here, we allege with particularity, not simply someone who's dissatisfied with the court, with the board of managers, but in fact, retaliation, bad faith, and malice. We point out how our plaintiff pointed out that the board did something very wrong. They tried to spend $3 million without the vote. The board got mad at them. The board sent out across Building Link all sorts of bad and untrue things about our clients. The board told the superintendent, according to our complaint, not to service these people. The board sat while giant holes in the roof came for 2 years. We gave a mold report showing that there was toxic mold. The board did nothing. We gave a noise code report. These are from independent qualified third-party vendors showing that it was blatantly violating the noise code. The board did nothing. It's only after that and after months and months of pleading with these people that we sued. We believe that given the inferences in our favor, under Fletcher and under the Alfred case, which Your Honor, Justice Higgett will be familiar with, there is no application of either the business judgment rule or anything in this context. These are fact issues that need to be resolved with discovery and, if necessary, at trial.
Can you address the derivative claims?
Yeah, so Your Honor, that's I think an open issue for the court. There is a statute, GOL 13101, which says any claim may be transferred unless it's either personal injury. We have no personal injury claims here. Statute, there's no alleged statute violation here, or public policy. Now, of course, it's for the courts to determine public policy. What we would say is the decision below, the court did not find that an assignment of derivative claims would violate public policy.
Yeah, but he was assigned to be the litigation person. He wasn't a member.
That's correct.
His wife was the member, which would otherwise have rights like that.
That's correct. And what we would maintain is that within a standing transfers with the assignment. And so the legislature has spoken and said that they in New York, you can assign any claim you want except for certain categories. And it's incumbent upon a court, if it's going to reject an assignment, just to articulate one of those categories that it falls in. And here it doesn't fall within any assignment, any exception. We acknowledge that ordinarily.
That was an assignment of litigation claims. It's not assignment of the condos, of ownership rights.
That's correct. So Your Honor, the condominium itself owns the derivative claim. And whether it's the husband or the wife who's bringing it, the condominium continues to own it. So in that respect, continuing ownership.
That's not the point. The point is whether or not your client is vested with an ownership interest in order to make the derivative claim. Obviously, the condo, you want to force the condo to do this.
Yes, Your Honor.
What case stands for the proposition that lacking ownership rights, you can bring a derivative claim? I never saw a case like that.
The assignor who was Mrs. Bent, had an ownership in the condominium. So when she assigned that claim, she assigned the right, the same as she has standing to bring any other claim.
She assigned an ownership interest.
She assigned the rights.
Litigation she only assigned, correct?
That's correct. She assigned
Like
the rights.
selling a cause of action.
She assigned the rights attendant with her ownership interest. She did not assign her ownership interest itself.
Okay.
But we acknowledge it's an open issue, Your Honor.
Good afternoon, Your Honor. William Geller, Braverman Greenspun, on behalf of the defendant respondents. As Mr. Delaporte said, in this case, the board does not contest that the assignee has a viable claim against the board, the condominium as a whole, for the breach of the bylaws. The issue in this appeal is whether the assignee can expand his claims to encompass individual liabilities for 4 of the 7 board members without identifying any wrongful individual action that the board members took.
Can he say that they took it as a board?
Well,
they all got together and they all decided to do X.
First, he only alleges it against 4, but the issue is that you have to identify individual wrongdoing as set forth in the 20 Pine case, the Jarmuth case, the Graham case, the Hirsch case, the Frankel case, the
Well, this
Dixon
is
case.
pre-discovery.
It's pre-discovery, yes, Your Honor.
So
But-
has plaintiff had an opportunity to look at board minutes and such?
Well, he hasn't, all he has alleged is that the board collectively did this, and he has not alleged that any individual actions. He has also not alleged, this is as a matter of allegation, he has to identify something.
Well, he could replead.
If he choose to, he could
And
try.
in repleading, he would then be able to allege those individual allegations, correct?
If he were to do so and allege individual misconduct by any of the individual directors, that would be a different case. He has not done so. He has not elected to do so in this case at any time. If after discovery it were found that even if these individuals were dismissed, that they did something individually, maybe he could replead then, but there is no allegation here that any of them did anything other than act as a body. And to allow it to go, Mr. Delaporte alleges the Fletcher case, but the Fletcher case specifically says, even though individual defendants, individual directors can be found held liable for individual torts, they went through and said this individual defendant was alleged to have conducted this tort, and other ones, since there was no tort alleged against them, that they were not, that the case against them were dismissed at the pleading stage. This would also eviscerate the bylaws section 215.1 that says each individual director is only liable for his individual misconduct, not misconduct of the board as a whole. There's an exculpation clause that
But
says,
if the board commits a tort as a board, then they would be individually liable as well as liable as a board, no?
no, it's if the individuals, you have to identify the individuals. All they're saying is that the business
So a
judgment.
board can commit a tort against one of their residents and because the board did it, it's okay?
If the board, well, first of all, the other issue here is that.
Wait,
Okay,
finish
no, no, no,
answering my
I'm
question.
sorry. So if without identifying misconduct from an individual board member, then.
You're not
individual-
answering my question. You keep on saying the same thing. You're not answering my question. But go
Question
ahead.
is that if the board, if the individual member is not identified as having committed the tort, the individual member cannot be held liable. The board can. The other issue here is there's no individual misconduct.
So, counsel,
There's non-action.
Counsel, I thought that when plaintiff was running for the board, they individually denounced the plaintiff and made individual claims on their own behalf. Isn't that in the complaint?
The only thing they allege when he was running for the board is they said, vote for the board to reelect the board.
No, they also sent out disparaging statements about him and alleging that he was trying to harm the building and the shareholders. I mean, I'm still talking.
Sorry, Your Honor.
Created animus against him, etc. So it wasn't just as you described. It was a little more detailed than that.
The allegations that they have specifically are that he threatened litigation and that they questioned his motives. That doesn't indicate.
That was, my point was that was not sent collectively as a board. I believe that certain individuals sent them as well.
No. The allegations are and the facts are that it was sent as a board. No individual is identified as having sent.
It said the individuals. It didn't say the board in the complaint. You're right. It doesn't say the 4 names. It says those individuals on the board.
Right, but the board is 7 members, and he never explains why it's only 4 that are sued and why these individuals are sued. But also, it says the board collectively, and it even says that it was counsel who ghost wrote it on behalf of the board as a collective body.
Thank you.
Thank you, Your Honor.
Whoops. Very briefly, although we don't think it's necessary, we did seek leave to replead, and that was denied. With regard to why only 4 of 7 were named, the structure of this condominium association has a commercial board of 2 members, a residential board of 5 members, and then a combined board of 7 members. So the 5 handle residential things, the 2 only handle commercial things. We didn't name the 2 commercial people. Also, one of the 5 was a recent add-on to the board, so we didn't think it was appropriate to add him. As far as discovery, answer Your Honor's question, no, we haven't had discovery. And beyond that, Mrs. Bent, as the owner, before filing this suit, put in a records request, which every condo owner has the right to have. She didn't get any records. She then at least attempted to assign that claim to her husband. That was dismissed. So we're in a situation where we have a double whammy. They didn't give us discovery, and they didn't even give us the documents that every that every condo owner is supposedly entitled to, which in our view makes it even worse. As far as the bylaws, there is an exculpation provision, as there is in every one of these things. It doesn't apply to gross negligence and willful torts under both the wording of that provision and under just standard New York law. Thank you, Your Honors.
Thank you. And last but not least, people of the state of New York versus GPB Capital Holdings. You may proceed.
May it please the court, my name is Hunter Carter. I'm with Aaron Fox Schiff. I represent defendants, appellants Jeffrey Schneider and Ascendant Capital. I have reserved some time for rebuttal. As you know, this case was initiated by the people through the Attorney General on the very same day and in obvious coordination with the Department of Justice filing a criminal indictment against my client, Mr. Schneider, and 2 others, and with the SEC filing a civil action against our clients and other defendants related to investments by sophisticated investors in private equity funds called the GPB funds.
Was your client pardoned?
One more time?
Was your client pardoned?
Mr. Gentili's client received a commutation of his sentence. My client, Mr. Schneider, is sitting in jail. So almost immediately after this case was filed, the motion court issued an agreed stay order, which by its terms was due to last until the final determination, in quotes, of the criminal action, and that has not occurred. Without the requisite showing of good cause, however, the AG jumped the gun and sought to vacate the agreed stay order while 3 sentencing matters remain pending at the federal district court level and while an appeal has been filed seeking a new trial. The motion court agreed with the AG without giving due consideration to the factors necessary for the application of the CPLR 2201 stay, which under this court's precedent in Britt versus International Business Services is a compelling factor when a criminal defendant is invoking the Fifth Amendment. And in this case, that's important because his self-incrimination liability or exposure continues throughout the time that sentencing remains being redecided, forfeiture, and restitution, as well as the appeal seeking a new trial.
Is there an opportunity for testimony in the sentencing phase in federal court?
There was a full day trial on forfeiture, which remains sub judice and hasn't been decided, so it could be reopened, and absolutely it could be considered. Second,
And
on
he
the
testified in it in the first instance?
I'm very sorry, I couldn't hear you.
Did he testify in the
No, ma'am.
proceeding in the first instance?
No, ma'am.
So
Invoked
that
the
the
fifth.
likelihood that he would testify, should it happen again, is
Correct, but if Justice Borach's order requiring initial disclosures and discovery responses and everything else in the civil case were to move forward and not be stayed,
Well,
that would be
aren't
used.
there civil cases going on in other jurisdictions where presumably discovery is going forward and the sky hasn't fallen down?
I'll try to break that into the two parts as I understand it. There are numerous other civil cases going forward. We filed a form with the court showing that all of them are stayed except for the nationwide class action. So Justice Crane and Justice Chan before her issued a stay of a civil action on these same facts in the Supreme Court.
So, sir, is your concern that if the stay, if Justice Borach's order is given effect, then your client is going to be put in the position of either having to invoke the Fifth Amendment in the New York civil proceedings, and that will carry with it certain consequences, or give testimony, in which case he may make admissions that could potentially be admissible in some criminal proceeding?
In the ongoing criminal proceedings, including the potential for a new trial, you've got it exactly right.
What ongoing criminal proceedings? Because whatever is left in the federal jurisdiction is the appeal to the Second Circuit,
That's
isn't
not
it?
correct.
No?
There are
What
three
else is going on?
sentencing matters still live at the district court. And the way this works, it may be a little unusual for people to get their head around, but a judgment of conviction has been appealed and that was stayed, and then the stay was lifted, notwithstanding that there are three matters of sentencing that remain to be decided. Under Federal Rule of Criminal Procedure 32, that rule requires that the restitution and forfeiture order
Counsel,
be
I thought-
rendered and that the judgment be amended under Federal Rule of Criminal Procedure 36, and then that can go up on appeal. But it's the judgment of conviction that's on appeal.
So I thought your client is sitting in jail because he was sentenced.
He was sentenced to a time in prison. There are
What
other aspects.
So can you please be more specific? What other aspects of the sentencing that remains?
Sure. Unlike the state procedure that a couple of the cases cited by the Attorney General refer to, where a civil forfeiture case gets to proceed after a certain point because of the criminal procedure code section, in federal court, it's a matter of law. Restitution must by statute be decided by the trial judge and has not been decided yet here. Forfeiture must be decided. It has not yet been decided here. There was a full day hearing on it.
But here, the court is not going to be deciding that all by itself, because we have companion SEC cases which are also exploring how to make whole all of the investors who have been defrauded, right?
Partially,
And that's
partially,
going on right now, correct?
partially right, partially wrong. The SEC's case is currently stayed, but for a receiver whose chief responsibility is to preserve evidence and make distributions and gather all the assets, and has done so.
And that's what I'm interested in, making distributions. So is New York State at the table getting any of those distributions in light of this stay?
New York State has made, I gave you a partial answer before, so I want to make sure I give it a complete one. There is a nationwide class action in Texas in which the receiver for the funds and the plaintiffs for the representative plaintiffs for the investors have reached a settlement to assign those claims to the receiver to continue to bring them. Those claims have been the subject of some discovery, a significant motions practice.
Those are
New York
claims and those are claims out of Texas? Texas
It's a
investors?
Texas federal case. It's a nationwide class action.
I understand. I heard you, and I understand what national means. Okay, so my question is, are the litigants who are at the table getting distributions, are those all non-New York State?
That's incorrect.
Okay,
That's
so
incorrect.
so tell me, how many New York State investors have received any of those distributions from this receiver in the Texas?
I don't have the number at my fingertip, but a lot. There are distributions from the class action and
I can't wait
distribution.
to see what he has to say about that a lot, but okay.
Just to finish the answer, there are distributions from the receiver totaling in excess of $400 million to all investors in the funds, according to their rights in the funds, all, including New Yorkers. And second, there have been class action settlements in the class action case in Texas based on the wrongful conduct of auditors and others. Those distributions have gone to all investors, all. Okay, so the receiver is seeking to collect funds and distribute them to all investors. New York is not cut out at all. The risk of inconsistent adjudication is that the New York AG wants to see that money distributed differently than the Eastern District of New York, which approved the receiver's plan of distribution. That's one of many.
Well, I mean, look, the fact that the Eastern District has decided one way doesn't divest our New York State Attorney General of having a say in protecting her constituents.
I didn't say it did,
Okay,
but I did
it's
say
all right.
there's-
That wasn't a question. That was just a statement on my part.
Very well.
You'll
May I
have time on
conclude?
rebuttal.
Okay.
There's no question.
Good afternoon. May I please the court, Zoe Bunnell on behalf of Appellant David Gentili. I won't relitigate what's in our papers and what Mr. Carter has already said on that. I do wish to sort of clarify a few of the things on distribution, since that seems to be an area of focus for your honors. So the receiver was appointed by the SEC court while that case was still stayed, simply to liquidate basically all of the remaining assets of the funds, which were substantial. So there are over $1 billion in remaining assets with the funds, which is a little bit why this case is a unique case, and the facts are unique in that all of the factors under CPLR 2201 weigh in favor of continuing this stay in order to maximize the recovery to investors. So it's our position, and with these facts we've tried to lay out in our briefing, is that the receiver was appointed by the court in the SEC action to liquidate the assets, which takes time because they're private equity invested in businesses, had to sell them, had to understand what was left, had to then figure out all the investors and the extent of their investments that they've not received back already in distributions throughout the course of the private equity investment. So it's been a long process, but what the receiver's done is now liquidated all the assets, has over $1 billion in liquid funds, basically, that it now is already distributing to investors through the plan of distribution that the SEC court approved. So why it's relevant is that investors are already receiving recovery of their investment, and as estimated by the receiver, they receive a full recovery of their investment through this process. The risk of letting this case proceed while that's happening is that it'll deplete those assets and then reduce the amount of funds available for the investors through that distribution process.
But it's depleting those assets to whom? To investors. I don't understand.
So the reason that's relevant is that because
They're not saying it would go to people who did not invest in the
No, Your Honor. Deplete the available assets because of the advancement orders that are in place here, where GPP Capital, through the remaining assets that it has, that the receiver is overseeing, has court-ordered obligations to advance litigation costs for a number of parties, including both of our clients and GPP Capital, who is also a defendant here. And so by letting this case proceed, necessarily our clients are entitled to present a defense, and their costs are ordered by the court to be advanced by GPP Capital, and thus those funds will come from the available pot that otherwise would go to
We're worried
investors.
about paying the defense.
It does.
That's what we're talking about here.
Well, that's already ordered by
that the state should not have a seat at the table because they might seek compensation that will then deplete the funds of attorneys.
Yes, which seems like an odd point for me to be making, right, as defense attorney, but it's why this case is so unique, and that all of the factors, usually the prejudice to plaintiff may weigh in a different way than the prejudice to defendants by self-incrimination and the lot. But here they all weigh in the same way because investors, the plaintiffs, that plaintiff's interest purports to represent, are harmed by letting this go forward now while those assets remain at the receiver's distribution. So by letting them figure that out, let this go, and there's no harm to plaintiff or minimal harm to plaintiff by letting this case, forcing this case to proceed early.
No harm versus minimal harm is a different equation.
Well,
right?
I understand, Your
Honor.
Honor.
What is minimal to you might not be minimal to them.
I understand Your Honor's concern of the plaintiff in being allowed to act for New York investors specifically, whose interests are being equally treated with other state investors by the receiver. And so I understand there might be some harm from Your Honor's perspective, but I think from the investor's perspective, who they purport to represent, getting a quick and full recovery is the principal interest that they have, and that's served by letting the already court-ordered process that's well underway with $400 million already distributed, $721 million remaining to be distributed, to move forward with that process, in addition to the class action settlements.
Thank you.
Thank you.
May it please the court, Danny Lee for the Attorney General on behalf of the people. Supreme Court properly exercised its broad discretion to lift the stay of this civil action. The stay was imposed 5 years ago, pending resolution of an active criminal action against Gentili and Schneider.
It's not over.
It is over, and
No, it's not over. It is not over. We still have proceedings that are open. There is an open appeal, and, you know, while it is not highly likely, reversals have occurred in the federal court, so it's not over.
So let me first address the forfeiture issue and then the pending appeal. Their argument is that the only issue remaining at the district court is the calculation of forfeiture as to Schneider. But the Federal Rule of Criminal Procedure 32.2, which they cite, says that a district court can enter a final order of forfeiture as to a defendant before they calculate the actual amount of forfeiture, and that's exactly what happened in this case. Judge Kovner issued an order of forfeiture as to defendant Schneider on May 7th, 2025. She said that she would amend that order later when she calculated the total forfeiture, and then the judgment itself entered on May 15th, 2025 includes the forfeiture, and that's at page 94 of the record. And we know there's a final judgment as to forfeiture because they filed a notice of appeal to the Second Circuit that said final judgment was entered at the district court on May 15th, 2025. So their forfeiture argument is totally a red herring. They also say that there are still restitution issues at play. There aren't. The government is no longer seeking restitution from the defendant.
Counsel, I'll speak for myself. I'm familiar with the Stevens rule that under the New York CPL, the criminal proceeding terminates or is completed upon the entry of judgment of conviction and with the sentence. Is the rule different under the federal rules of criminal procedure? And if so, are any differences material to that Stevens line of authority as we would normally treat it in this kind of situation?
No, there isn't a material difference because even in federal court, conviction and sentencing constitutes the final judgments, and that's why they have an appealable order and why they can go to the Second Circuit. If you agree with their arguments, then the Second Circuit wouldn't even have appellate jurisdiction over their appeal.
But I think the question, well, you can go ahead.
I was just going to say, I think that the nomenclature, at least in the state, under New York State criminal procedure laws, the criminal proceeding terminates. That doesn't mean upon the entry of judgment. It doesn't mean that the defendant loses his or her right to appeal, but for whatever reason, that's how our CPL chooses to characterize one of the significances of the entry of judgment. Do we have is there a similar consequence under the federal rules of criminal procedure when a sentencing and entry of judgment occurs that the proceeding is terminated? Because as I understand some of the law in this area, one of the reasons why we are more likely to vacate a stay that had been in place pending the pendency of the criminal proceeding is because our legislature has chosen to characterize the entry of judgment with sentence as the termination of the proceeding.
That's correct. There's no material difference. Whether you're looking at the case law of this court, the Court of Appeals, the Second Circuit, final determination of the criminal action happens at sentencing. If we're going to be functionalist about this, we should just look at the fact that the circumstances are entirely different. Why did the defendants move for a stay in 2021? And why was it granted? We didn't oppose the stay because the U.S. Attorney's Office of the Eastern District of New York requested the stay in 2021 because they were afraid that moving forward with this civil action would interfere with their criminal discovery schedule. That's why we consented to an issuance of stay. Now there's been conviction and sentencing. Those concerns are totally gone. So the Supreme Court clearly acted within its very broad discretion, acting as the manager of its docket to vacate the stay in light of all of the circumstances.
But we don't have to wait for the appeal to be decided.
That's exactly right. And this court said as much in Morgenthau, where a criminal defendant was convicted. They sought a stay. They sought a stay of the civil action related to forfeiture. And this court said the fact that there's a pending appeal has nothing to do with the fact that there's been a final determination of the criminal action.
That was a state case, wasn't it?
That's right. That was the First Department.
But here we're talking about a federal case.
It's true, but we're not defining the terms of a statute here. We're just talking about what did Supreme Court mean when it issued the stay order and it said, I'm going to reevaluate whether the stay is proper upon final determination of the criminal action. And
according to New York law, as opposed to according to federal law.
right, our argument is that final determination of criminal action has well-established meaning under state law, under federal law, and the Supreme Court was well in its broad discretion to determine that.
What is the harm to plaintiffs here in allowing the mechanisms that have already been put in place to play out? What is wrong with how it is functioning right now in terms of the distributions that are being made, the fund that has been collected? What is it that the state feels it needs to be in there in order to protect the interest of New Yorkers? Why? Why are we here?
I have two answers. The first is as to the state's interest. The state has a sovereign interest in the enforcement of its investor protection laws. And in this case, it is the only plaintiff in any of these civil actions that has the prerogative to enforce the Martins Act and the executive law to enforce its investor protection laws. This is especially necessary in light of the fact that, President Trump commuted Gentili's sentence from 7 years to 12 days. There is no pending enforcement action on the SEC's part, and we don't know what's
along
going
those lines, what relief is the Attorney General seeking in this proceeding?
The Attorney General is also seeking unique relief because it's the only party in the civil action seeking injunctive relief. In particular, the Attorney General is seeking injunctive relief that would permanently enjoin defendants Schneider and Gentili from selling or offering from sale to the public within the state any securities issued or to be issued, and that's at page 67 of the record. I also just want to address this receivership argument.
And is that particular issue, is there any other entity, party that can seek that particular outcome?
As far as we're aware, there is no other entity that is actively prosecuting a civil action where they're seeking that kind of injunctive relief. Their argument is that this action has to be stayed to effectuate the receivership. That is entirely baseless because the receivership order itself includes a carve-out for state enforcement actions. This is at page 606 and 607 of the record. The receivership order says that all civil actions involving the receivership are state, except, quote, all actions brought by the United States and all actions brought by any state within the United States pursuant to such states' police and regulatory power.
One more question. Are there other states that are a part of this litigation? Or is New York the only one who's not at the table?
New York is the only state that is actively prosecuting this civil enforcement action. And it is doing so pursuant to its unique enforcement powers pursuant to the Martins Act and the executive law. The receivership order has already balanced the interests. It has imposed an injunction order to make sure that its assets are preserved, while at the same time respecting states and the United States' sovereign prerogative to enforce their investor protections laws. I also just don't understand this argument that we have to stay this action to preserve the receivership funds because they're just kicking the can down the road. They're not seeking dismissal of the action. In other words, they're seeking a stay of the action. They're trying to delay the litigation of this case, but eventually the case will get litigated, and presumably there'll be litigation costs. So their receivership argument just doesn't work, either just looking at the receivership order itself or looking at their argument about preserving costs.
Thank you.
Thank you.
All right, you have rebuttal time.
Very quickly, the injunctive relief the state seeks is to prohibit that which the statutes already prohibit. Second, the funds that are marshaled for distribution to investors are paying advancement costs. Right now, as I stand here, it would not be paying. If there is a reversal on appeal, if there is a reversal of the conviction, that'll be a very different scenario, and the costs in the civil cases will be very different. If the conviction remains, it'll be a very different scenario. And so stopping the legal spend right now to distribute funds to investors while they sort out what's going to happen with the criminal case is imperative. A complete answer to the question you asked about other states is there are 5 other states, all of which have stayed their proceedings until the final resolution of the criminal case. I'm sorry.
Which states are those?
Oh boy. Alabama, New Jersey, Georgia, South Carolina, Illinois. What about Ohio? No. I did my best from memory, Your Honor. So advancement depletes the funds available to the investors. That's crucial to understand.
All right. You have time on rebuttal? 2 minutes.
Just to follow up on a point he was making, he continues to draw a distinction between New York and other states, that New York is the only one actively prosecuting the injunctive relief just sought. Another state has deferred to the court in the SEC action and specifically dismissed GPB Capital, at least, from that action while the case remains stays because its interests are already being served by the distribution process that's being overseen in the SEC action.
How do you answer your friend's point, though, that the AG is in addition to any restitutive or financial type relief, seeking equitable remedies such as an injunction, which is, within its police powers? And would we be intruding on those powers if now we reinstituted the stay?
Yes, Your Honor. I think not intruding on those powers because, again, we're not seeking a dismissal. We're simply seeking a stay. The harms that he would seek to enjoin are already prohibited by statute and law, and there's
So are you saying Mr. Gentile, who is no longer in prison, is prohibited from engaging in stock trades today?
He is not currently prohibited from engaging in stock trades today.
He what?
He is not. He is prohibited from defrauding anyone.
Well, everybody's prohibited from defrauding.
Precisely.
And he obviously did not adhere to that. So since he has been let go, why is the state's interest in making sure that they pursue the injunction to make sure he never, ever is part of a fund again? Why is that not a legitimate interest for this state?
I defer to Your Honors if you consider that a legitimate interest. I think where I would place it in the context of our current dispute is whether that interest exceeds all the other interests in the required balance.
Well, in light of the damage that was done on this fund, it seems to me it's pretty high.
Yes, Your Honor. I think he is no longer involved with GPP Capital, which is the mechanism through which he did this.
Right, that doesn't stop him from starting another one.
I think that there...
Nothing. There's nothing right now today, no SEC order, no prohibition, nothing that would prevent Mr. Gentile from starting up another fund and doing this all over again. Correct?
To my knowledge, there's not.
Thank you.
Thank you very much.